Anything. And what is this? What are we on? May 19th. Jesus.
Ooh.
I'm not a lefty.
We'll get it.
All right, welcome to the Sunshine Ordinance Task Force meeting on May 19th, 2014. We're starting at 4:07. Mr. Clerk, can you call the first item?
On the call of the roll, Member Nee.
Here.
Nee present. Member Washburn. Washburn did call. She will not be able to make it today.
Thank you.
Member Pilpel.
Present.
Pilpel present. Member Sims. Sims absent. Member David.
Present.
David present. Member Highland.
Present.
Highland present. Member Oka.
Present.
Oka present. Vice Chair Fisher.
Present.
Vice Chair Fisher present. I believe we need to take action concerning, do we need to take action concerning having the Vice Chair preside over today's meeting?
Did you call Chair Grant to see if she's present? I don't think you did.
Mr. Clerk, I don't believe any such action is
Yeah, we don't.
necessary. My read of the rules and regulations is that until such time as a new chair and vice chair are elected, in the absence of the chair, the vice chair takes the presiding duties.
Thank you very much.
I've done this before. And one item I do, for the record, I neglected to say this is a special meeting of the Sunshine Ordinance Task Force. Mr. Grant Garza, can you sit down, please? We haven't called you up yet. Thank you.
I didn't.
That's fine. Go
I
ahead.
believe there is a request from the complainant on item number 2 and 3 to hear item 3 before item number 2.
Duly noted. Anything else?
There are no other agenda changes that I know of.
Okay, I would like to actually combine items 2 and 3, so we can hear them in order of 3 and 2, 2 and 3. It doesn't matter, they're going to both be together. Mr. Grant Garza, I'm going to give you 10 minutes total to present your case on both of those. And is the respondent back there? You guys, are you okay with that? Yes. Okay.
Am I to start now, Madam?
Let me
Madam-
read the...
I was going to start with jurisdiction. Hold up, let's go. Member Nee first, and then I'll go to you.
Before we start on the substance, we would have to accept jurisdiction.
Yeah, I was getting to that.
I was actually going to ask if there were any other agenda changes or if we're just on to items 2 and 3.
I don't have any other. Do you have anything else? I didn't have anything
There are
else.
no other agenda changes that I know of.
Okay, so let's talk about is jurisdiction accepted by both
May I-
parties?
may I read
What?
the
He needs to
items?
read the items.
Could you read the items first? Thank you.
Item number 2, file number 14003, complaint filed by Jason Grant Garza against the San Francisco Police Department for allegedly violating the Sunshine Ordinance Section 67.21, 67.25, 67.26, and 67.27 by failing to adequately respond to immediate disclosure requests made on October 24, 2013 in regards to policies regarding video cameras and retention, contact information of ADA disability representative, and other related documents. Item number 3, file number 14004, complaint filed by Jason Grant Garza against the San Francisco Police Department for allegedly violating the Sunshine Ordinance, Section 67.21, 67.25, 67.26, and 67.27 by failing to adequately respond to immediate disclosure requests made on September 21st, 2013 in regards to videos, pictures, and audio recordings from the Northern Station and other related documents.
Okay. Do I have a motion for jurisdiction?
So move.
Second.
Okay.
Madam Chair?
You got a
Acting
comment?
Chair? Is that a motion to find jurisdiction on both?
Yes.
Okay, we can do that? Okay.
Can we call this pass without objection? Everybody okay on jurisdiction?
Public comment. Public comment.
Do I have any public comment?
On jurisdiction or on the members that, weren't present?
On jurisdiction.
Jurisdiction, which you cannot comment.
Yes, I'm Peter Warfield, Executive Director of Library Users Association. We are not connected to these cases, but I find it highly objectionable that they are being taken together and not in the way that they're shown on the agenda. If they were going to be combined, they should have been combined on the agenda so that everybody, including particularly the complainant, would have an opportunity to know what was going to happen. You also, rather one-sidedly as chair, asked the respondents, are they okay with the combining of the two items? You did not.
I asked if that was jurisdiction.
You did not ask the complainant. So I think it's highly objectionable to take both of these items together. With respect to jurisdiction, I would be speaking on one or the other if this were in the normal format. But with respect to jurisdiction, we don't have any objection to your body taking jurisdiction, as you likely will do and usually do. Thank you.
Thank you. Okay, any other public comment? Seeing no. Okay, we've got one more.
Just briefly, Thomas Piccarello. Yeah, I strongly support the matter being consolidated. Same set of facts, just a different date. You need to do something about serial complainants. I see right now you have 6 people, and hopefully you'll be able to, hang in for 3, 4, 5 hours so that you can get through the agenda. So strongly support consolidating many more cases that you have filed. Thank you.
Thank you. Any other public comment? 2, 3, 2, 1. Seeing none. Where did I leave off? Can we say this passed without objection? I'm looking to my left, looking to my right. You got that, Mr. Clerk?
Yes.
Okay. So, people of the gallery, bear with me. We are now going to move forward with the case. The complainant will get, I'm going to give you 10 minutes to make your case. And after that, respondents, you guys are going to come up here. You can have as much of 10 minutes as you want or need. And then members of the public will be able to speak after each one, and we'll go from there. So, Mr. Grant Garza, you have 10 minutes.
Okay, well, first of all, I want to say that since I wasn't asked, I want to voice my opinion on the fact that they shouldn't be combined and that I don't feel that this is due process. I've had this conversation with you guys many times. The prior speaker who got up about precedent and said, serial filers like me, obviously he forgot the other end, serial offenders, who, I'm constantly bringing back up here and reinventing the wheel because you guys have no precedent. No precedent whatsoever when it comes to listening to any cases, any stuff that's decided before, the person has to come back multiple times. I, for example, with the Department of Public Health, Anyway, moving on, since apparently my objections aren't going to be heard and my due process is going to be waylaid, considering there's only 8 members that are supposed to be sat, only 6 here, but apparently the majority of 8 is going to be 6 votes required to pass anything. Once again, no due process, which is what I've said all along, but at least I will continue to tell the truth to the Ministry of Sunshine. All right, first of all, when I originally sent my IDR to the police department, it was in regard to what I've been in front of the Ministry of Sunshine many, many times about, which is denial of health care and telling you people that, there is no enforcement, there is no anything, so I have to continually come back here to try to get my health care. What had happened was that I was following up at Northern Station in regard to my health care and a particular complaint that I wanted to file for assault for being denied health care by one of the sheriff's deputies on 9/18/2013. At that point, I went ahead and I believe it was on the 21st, sunshined the police department for those videos, and all the paperwork for that illegal 5150. At that point, a few days later, I received something telling me from Miss Maureen Conifrey, I guess who was the correct person, telling me that after her timely response and a thorough and diligent search, that the officer who detained me on September 19th was Mr. Fulano Star number 1890 and had no other documents responsive to this. Curiously enough, the IDR mentioned the fact that the false and illegal arrest was on 9/18. Apparently, the very competent people at the legal department or whoever's in charge of public records, after a thorough and detailed investigation in which, of course, they never contacted me, never spoke to me, gave me the wrong information. When I wrote back and said, well, I certainly would like for this to, for you to admit that you've sent me the wrong information, well, that just went sailing by too. The principle of good faith, clean hands, it's an awfully interesting thing. All right, I was also told that the videos did not exist. So, part of this was like, well, if the videos don't exist, is there any policy that the police department has in regard to the retention of its videos at the police stations? After 9/11, Homeland Security, I'm pretty sure that the federal government required all police stations and all agencies, to try to deal with anti-terrorist things and to come up with solutions. And I would imagine that having video cameras that record would be part of this. But I was informed that the video cameras do not record, that they're simply there for viewing in real time as people walk in. When I asked for the policies, I was sent to the incorrect place, DTIS, which of course doesn't facilitate the policies. Oh, the plot thickens. Okay, at that point, I said, well, unfortunately, when I walked in with my video camera, and the incident can be seen on YouTube as to what happened that day and how I was falsely 5150. The incident also shows with my video camera the fact that, as I said, they've claimed that those cameras weren't recording, but yet somebody behind the window in their job duties, being behind in the confidential area, recorded me on, I guess, maybe their personal camera. That's on the video. I also requested that video. I was denied that video in addition. For them to falsely 5150 me and say that I'm acting a certain way, and then I can't get the videos. Oh, and by the way, there's no policies for the videos. Just stinks to high hell in 2014 in this society. All right, so at that point, when I wrote Ms. Conifrey back and said, well, excuse me, but you're incorrect, I need for you to go ahead and send me the policies and everything, that never happened. When I went in to follow up to the police station, because the respondent is supposed to be as helpful as they possibly can be, that never happened. I was told I was not going to be able to see that person and that I would not be able to follow up to the incorrect advice that I was given, to the fact that there was no policies, to question anything. Are we living in Russia? I'm confused. I really don't understand this. So at that point, I just continued. And then I sunshined them again a month later, because I had asked for the policy civilly without sunshining, and of course I'd been sent the wrong information. And when I wrote her back and said, well, can you please treat me like a human being, and have some professionalism here, and I'm sure that you as the legal person understands what the word policy means, why the misdirect? Nothing came of that either. Now, the problem that I'm having is that in addition, if you go to YouTube and look at the other videos, I went to other police stations to ask them if their cameras recorded. Would you all guess to venture what the answer was? Yes, they do record, which of course makes logical, total sense in this post-9/11 terroristic world. All right. The San Francisco, I asked them to send me a copy of the policies used by the San Francisco Police Department for their video cameras, retention, recorded data, whatever, to ensure the reliability and correct performance of said cameras and security measures in and around the police stations. Their response was that they had no responsive documents to this request. So we live in San Francisco, the 14th largest city in this country. This is 2014. And there's no cameras working at the police stations so that they can falsely 5150 you and claim that there's something going on with you. And then when you ask for the stuff that they're supposed to provide, for example, the policies that would negate this, you can't even get that. Unfortunately, I have been in front of the Ministry of Sunshine many times. Mr. Nee can tell you, for 10 years now, trying to get my health care. This is all about my health care. This was about me going in and following up on the denial of my health care and trying to file an assault charge against the San Francisco Sheriff's deputy for, an incident, and being played at the police station and being falsely 5150 there because, they just can't handle the truth, apparently. Well, unfortunately, I guess I'll tell you like I told you last time I was here trying to follow up on my medical care. I truly believe that when I leave, I still won't get any medical care, and I still won't get any help from the police department, and this Ministry of Sunshine will, of course, fail again, because if they send them to ethics or anything else, well, Mr. Nee can quite clearly tell you what happens when stuff gets sent up to ethics. That's why I'm here reinventing the wheel each and every time, because there is no precedent. Contrary to what you were told by the public about me being a serial complainer. Well, apparently, there are serial offenders, there's no precedent, and their wheels got to get reinvented. I've been doing it for 10 years over the Department of Public Health, and, the fact that my own medical records are public records and they keep denying it. So, this is pretty similar. This is the same thing that's going on with the police department. I've asked for what's legally required. When I've tried to follow up on their incorrect information, I was totally waylaid. When I asked for some professionalism to at least admit that they'd sent me the wrong information, never got that. When I went in to follow up and say, hey, this is wrong, well, you're never going to see that person. Well, under Sunshine, I'm supposed to be helped here. Very queer. Thank you.
Thank you. Okay, so do I have any members of the public who would like to introduce facts and evidence in support of the complainant? Okay, seeing none. Over the podium, let's bring up the respondent or respondents. You can have up to 10 minutes also. They will. And can you identify yourselves also?
Lieutenant Christopher Woon from the Police Legal Division. Sergeant Anthony Pedroza from the Police Legal Division. Good afternoon, task force members. Mr. Garza, I welcome your concerns and issues, and I thank you for bringing them here today. Now, the first issue that was brought up regarding complaint number 14004, this was received at Police Legal on September 23rd, and in essence, this IDR compiled of several requests. The first request was regarding documents regarding emails, correspondence, logs, notes of conversation regarding the 5150 event. The second issue was regarding the videos, pictures, and audio recordings from Northern Police Station that he requested as well. The third request was regarding documents regarding charge slips, police incident reports regarding the 5150 detention. The next request was regarding name and badge number of the officer, regarding the being handcuffed and escorted by police car to the PES. The last request under this IDR was for paperwork sent, received, email, transmitted to all agencies. All requests, paperwork received, email to all other agencies. Now, Ms. Conifrey is the police representative regarding this incident, And since this is an IDR that was sent on the 23rd, she responded appropriately also on that date, on the 23rd, and responded in an email to Mr. Garza, and responded with the response saying that the report that he requested was exempt from disclosure under 6254C of the Government Code, and then requested an extension to provide other further detail regarding the circumstances of his request. Three days later, on September the 26th, Ms. Confrey sent an email providing information to Mr. Garza on a rolling basis, provided information such as the officer's name that he requested and a star number, also provided Mr. Garza the information regarding the video from Northern Police Station. And the response that Ms. Confrey provided to Mr. Garza was that it was not taped per Captain McEckering from Northern Station, but she contacted the captain there, providing due diligence and researched this question for Mr. Garza, and found out that there wasn't videotaped. It was in real time only. And the video that Mr. Garza was inquiring about an officer taping the incident, that video was deleted, so there was no responsive documents for Mr. Garza regarding that. And regarding the report that Mr. Garza was inquiring about regarding the 5150, that is exempt under disclosure under 6254C of the Government Code. Now, with that, I want to explain the circumstances with that. So, Mr. Garza requested the incident report for that mental health detention incident. On October the 1st, which is 8 days later from the initial request that Mr. Garza requested this detention report, we ultimately gave a response back to Mr. Garza stating that it was exempt from disclosure under 6254C. However, he could still obtain that report by going to the records division downstairs at room 475, provide Mr. Garza the contact telephone number, the address where he could do that, and even provided Mr. Garza with the proper procedure how to get it with an attached request form. So Mr. Garza did get the information if he wanted to go to that location to provide in that fashion. If we were to provide it in a circumstance such as a PRA request, a Public Records Act request, and Sunshine request, then under 6254.5 of the Government Code, we would have to give this information to other requesters in the future. So in order to protect his privacy rights and at the same time still be able to provide him this information that we requested, we directed it into the proper entity to actually get it without violating his rights in that fashion. Now, regarding complaint number 14003, regarding the October 24th IDR, this, you have to understand that between September 26th and October 24th of last year, there was numerous conversations or emails sent back and forth from Ms. Confrey and Mr. Garza requesting various information. And on this IDR, dated on October 24th, most, if not all, the responses were given to him prior to that event already. But to ensure that he received this information and he understood this information, Ms. Confrey also provided to him again in a separate email on October 25th, which is the day after the IDR was sent. Specifically, regarding the request that he asked for, was regarding the videos again, regarding from Northern Police Station. And on September 26th at 1:50 p.m. in the afternoon, Ms. Confrey sent a response back to him regarding that video was not taped, and we had no responsive documents in that sense for him, and provide the officer's name and star number. Also, regarding how to get the, let me see here, regarding the report, it was exempt from disclosure. However, on October 1st, she already let him know to get that report, he would, the proper procedure would go down to the records room to get that. Regarding another request, regarding the video retention data from Northern Station regarding the policies and procedures regarding that, Ms. Confrey directed Mr. Garza to go to or contact the city IT department and provide the phone number from them. Ms. Confrey researched that item and discovered through Captain McEachran that that was the proper venue to contact and to research. Regarding the issue that Mr. Garza had regarding the ADA Disability Representative Title II, regarding policies, position, filling it from the San Francisco Police Department, Ms. Confrey answered that on October 16th at 1:57 p.m., stating in essence that this representative that we had for the police department was for in-house members of the police department. And she also provided a document that outlined that process and procedure as well. However, our representative, in an effort to further assist Mr. Garza, Ms. Penny Tsai also contacted Mr. Garza on the telephone that same day and also memorialized that in an email stating that she referred Mr. Garza to the mayor's office on disability, provided him a phone number, location where he could research that issue as well. Like I said, on the day after of this incident of the October the 24th, the IDR, Ms. Confrey also sent an IDR representing that information that he requested to ensure that he received that information. So that's all documented in the email as well, dated on October 25th at 1:52 p.m., where in essence she broke down the email into a question and response and provided him with the necessary responses. Regarding another request that Mr. Garza made, stating that he wanted a copy of an incorrect findings report through his thorough and diligent investigation, incorrect response and incorrect information. That was unclear, and Mrs. Confrey emailed Mr. Garza regarding that and asked him to clarify that request, and also further provided him information that that report still, if he was referring to that report, was exempt from disclosure. However, if he needed to get a copy of it, he would go down to a records room to get that. Now, in summary, I want to say that the police department wants to be as transparent as possible and provide all the necessary information that the public needs. If they want any information that we'll be able to provide them as permitted by law, that is our obligation to do so, and we'll be happy to do so in that fashion. Regarding the circumstance regarding Mr. Garza, I believe that Ms. Confrey acted within the provisions of the Sunshine Ordinance and the Public Records Act, and she acted with due diligence to research these issues for him and provide him a response. If we didn't have a responsive document for him, Ms. Confrey either stated to him that we didn't have that document or referred him to the appropriate venue to gather that information that he requested. In conclusion, I want to say that we appreciate Mr. Garza's concerns and issues, and we want to let him know that we respect his concerns regarding what he would like from the police department. However, I feel that we provide the responsive documents that we had, and we acted within the provisions of the Sunshine Ordinance and Public Records Act. Thank you.
Thank you, Lieutenant. What was your last name? Was it Wu or Woon?
Woon, W-O-O-N.
Okay, don't go too far. So do I have any members of the public who would like to introduce facts or evidence in support of the respondent? Okay, seeing none, then I'm going to open it up to my task force members. I'm going to start with Member Nee.
Lieutenant Woon, please.
Who else? Anybody else?
You stated that Ms.
Yes, sir.
Confrey responded to Mr. Garza on the same day that she received the communication. However, according to the records we have, she was not the original recipient of that communication. The communication was originally sent to Chief Suhr and was not forwarded to Ms. Confrey until 2 days after the initial receipt of the request. I'd like to know why that delay in number one, why the delay in forwarding the request, and number two, why the delay in responding to Mr. Garza.
Are you referring to complaint number 14004, sir?
I am referring to the. I'm not sure which serial number you're referring to, but Mr. Garza's original IDR, immediate disclosure request, was sent to Chief Sir on September 21st, 2013, I believe, and he did not receive a response until 2 days later. Why that delay?
I understand, sir. And the response that I have for you in that, September 21st, 2013, at, I believe, 7:23 p.m. was the original IDR that was sent to Chief Sir. That is a Saturday weekend.
Friday.
And we received it on the 23rd, which is a Monday, sir.
Thank you. Another question regarding your introduction of the 6254C exemption. My reading of 6254C is that the record should not be released unless, if it would constitute an unwarranted invasion of personal privacy. Now, the record that Mr. Garza was requesting was about himself. It was about, I believe, had to do with his own medical circumstances and the circumstances of his detention. How does the release of a record about to the requester about the requester constitute an unwarranted invasion of personal privacy?
I'd like to explain that. So, Mr. Garza requested the incident report regarding his mental health detention report. Under 6254C, that I understand, is that records that are medical records, they're personal, would constitute unwarranted invasion of privacy if we were to release to other parties. So, for example, if we were to release it to Mr. Garza under the Public Records Act and Sunshine Ordinance, for him to give that report to him under PRA and Sunshine Ordinance, then we must release that report to other individuals in the future regarding that report under 6254.5 of the Government Code. So in essence, once we release it to one person, even though it may be the person that filed the report, we're obligated to release that report under the Sunshine and PRA to other individuals as well that request it in the future. Therefore, to protect his privacy rights and to satisfy his request to obtain the report, we directed Mr. Garza to obtain the report through the Police Records Unit, which is the policy of the police department, in that fashion so that his rights would be protected.
How are his rights any less protected if he gets them from the police records unit than if he gets them from your office or from Chief Sir's office? How are they any less protected?
Well, if he could get the report through the records division downstairs at room 475. Now, if he got it through the Public Records Act Sunshine Ordinance, then if there is another request in the future from an individual requesting that same report, we must give that report to that requester.
You're not answering my question.
And what's your question,
My
sir?
question is, you said you directed him to the police records unit with that request. You suggested he channel that request through the police records unit. How is his privacy any less protected if he gets them from the police records unit than if he gets them from the office of Chief Sir?
Well, my explanation once again is that once he gets the report from the records unit, they can provide it in that fashion. If we were to release this report through the PRA Sunshine, another party in the future that may request this information, we must provide that information to that party in the future. Now, if Mr. Garza received this report through the records division, on the other hand, and another individual requests the same report, the records division would most likely deny that request, though, therefore, in essence, his privacy would be protected because the party asking for that report and going through the records room, they would, in essence, will not get that report.
When you relayed that reasoning to Mr. Garza, which I assume you did you ask him if he felt his privacy would be unduly violated if the records were released?
I have not spoken to Mr. Garza personally. I'm sorry?
Well, whomever he dealt with then.
It was probably Ms. Confrey.
Okay, do you happen to know, or maybe Mr. Garza could answer this, did Ms. Confrey ask Mr. Garza if he felt that the release of those records would unduly violate his privacy?
I'm sorry, is that a question for me?
It's a question for either one of you. If Ms.
I don't have an answer to that,
If
sir.
Ms. Confrey is here, perhaps she could answer
Ms. Confrey is not here, sir.
Okay, perhaps Mr. Garza could answer that then.
Thank you, sir. What was the question again, please?
Question, you were told that there may be an undue violation of your privacy if the records were released to you, the records you had requested were released to you, because then if they were released to you from Chief Sir's office, anybody else who came in to Chief Sir's office could then ask for those records, and Chief Sir's office would be required under both the Public Records Act and the Sunshine Ordinance to release those records to anyone else who wants. So my question is, were you informed of this concern about your privacy, and if so, what was your response?
No. As a matter of fact, when I read the denial, I was led to believe that she was denying me those records on the fact that it was the officer's privacy that she was concerned about, not mine. Now, the interesting part is, this was for an IDR. Yes, I did go ahead and follow through with what she said, but that process took another week and a half, maybe 2 weeks before I even got those records. In addition, the information that is on the police incident report is the officer's take. It has nothing handwritten from me. It's simply what his take was on falsely, illegally 5150 me, and that's why I wanted it. But so when I requested that, they said privacy, and I was assuming she was meaning that I couldn't get it because of the officer, because basically I felt that was what she was trying to tell me about, the same thing about, not being able to tell me who the officer was. And then when she came back and said, on the 19th, which of course was the incorrect date, she gave me the officer's name and everything else. So I was never broached with, about an invasion of my privacy. I have no qualms about my privacy being invaded. The only qualms I have is, when it comes to my medical records and their privacy being invaded because of, a HIPAA regulation. This was not a medical form. This was simply, the arrest incident report that I was trying to get so that I could see how the officer had what's the word I want to use, had set this up so that, I could find where the discrepancies were and everything else. Now, again, let me once again repeat for the record, that I did follow up on what she told me, even though it was incorrect and late, and it still took another, I would imagine, 10 days. I'd have to go back and look. Once again, defeating the purpose of an IDR. Now remember, these IDRs were in September and October of 2013. It is now May. And IDRs are supposed to be used so that people can get what they need to represent themselves effectively against timelines. If, for example, we have a 6-month timeline deadline to file something. Well, it's been well over 6 months, and I still don't have what I need when I requested an IDR.
Mr. Garza, a question just to follow up on member
Chris?
Nees.
Chris, hold up. I've already got an order.
Good.
You're willing
You can
to-
go.
So that was
ahead,
my
Chris.
answer, Mr. Nee. I hope it answers what you asked. If not, ask me something more specific, and I'll be happy to answer it for you.
Well, I did have another question then for Lieutenant Woon.
You'll go next, Member Highland, and then...
If I may respond to Mr. Garza's response.
Yeah, well, Mr. Garza has said that your refusal, your concern about privacy was for the privacy of the arresting officer, not his own privacy. Is that correct?
I have no knowledge regarding that, sir, but what I can tell you is that on September the 23rd, Ms. Connery did send an email back to Mr. Garza stating the exemption that the report is being exempted under 6254C due to being a medical personnel record.
Okay. We're going to go Member Highland, Member David, and Member Pilpel.
Mr. Garza, a question for you. So the September 23rd letter quoted the 6454C exemption. She then sent you another letter on October 1st saying that that information was available at CISD and then gave you a report number.
At where?
At CISD.
The criminal downstairs.
Yes.
Yes. And that was when, did you say again?
October 1st, she followed
So
up.
for an IDR that was supposed to have been filled within 24 hours.
Let me ask my question. Did you then go down and get that information, and do you now have that information?
I believe I told Mr. Nee that I jumped through her hoop, and that took another 10 days or 15 days. I don't remember. I'd have to go back and look at my records. The videos are on YouTube of me going down there and requesting everything, and when I did go back and receive it. So everything is on YouTube, so that people will not say.
We're going to debate whether there was a timeliness issue there. That's not what I'm arguing with you. I'm just asking you.
I wasn't arguing, sir.
Were you able to get the information you wanted after that second communication on October 1st?
Yes, not timely.
Thank you. Thank you.
I believe. Member David? You're good? Member Pilpel?
All right, so there are a number of issues here. Let me see if I can sort this out a little bit. Let me start with Lieutenant Woon. So if I understand correctly, the videos that were alleged, there are no videos in the possession of the police department, and so you can't provide any videos because there aren't any videos available. Is that correct?
Correct.
Okay. And with respect to the other requests of Mr. Garza, you believe that those were responded to in a timely manner and that all the information that you had was provided except for the information that you withheld under 6254C. Am I capturing too much there?
The 6254C, what I understand, is the incident report. That information, we referred him to the records unit so that he could obtain that information.
Right, but you didn't provide that. Okay.
Yeah, so he did
but
get that
everything
information.
else other than that information that he was looking for, you believe was provided?
Either it was non-responsive, either it was provided to him. It was referred to a different the unit to have his information being given to him.
Okay. And I think I understand what your exchange earlier with Member Nee about a record, and once it becomes public, it's public for everyone, and so you were suggesting that he obtained it in a different manner so that it wasn't public, subject to the Sunshine Ordinance, which would then make it public to everyone.
Yes, in essence, we wanted him to have that report, but if he went to the proper channels to protect his privacy rights, because we were looking out for him so that he could obtain this information.
And protecting the third-party privacy rights of individuals is something that we do as a government, and that's the way that works.
I really think that's important to state. And also, regarding the initial September 23rd event where Ms. Connery responded back to Mr. Garza, where she invoked the extension.
She did.
I'm sorry?
She did.
She did. She invoked an extension on September 23rd at the 1:16 p.m. There was the response back to Mr. Garza where she exempted the disclosure from the report and also invoked an extension under 6253C. And the reasoning for that, I want to elaborate a little further regarding that, is that the request that Mr. Garza was not a simple, readily accessible, easily answerable question to provide to Mr. Garza. In essence, he asked for example, video from Northern Police Station, which is a separate field facility, different.
I understand. I would say in summary that her response of September 23rd on 116 could have been more detailed as to the reasons for the extension. That doesn't talk about field facilities. I mean, that is another reason for an extension, but that wasn't covered in her email. But aside from that, was her subsequent response, and it's hard to tell from all the various email chains, if that was provided on a timely basis within 14 days after the extension.
Yeah, so the 6253C1, I believe it does state the fact that it is a separate field facility with a different division of the police department, so located at a completely different address. So Ms. Confer, you need to do some due diligence and then
I'm not questioning that.
To provide an accurate response to Mr. Garza. So that was on September 23rd at 1:16 p.m., where she invoked that extension, and on a rolling basis, Ms. Confer provided information to Mr. Garza. The next response back after September 23rd was September 26th. 3 days after the 23rd, provided further information regarding the video, regarding the officers' information, and further regarding the video, I believe, as well. And the next event after that is October the 1st. October the 1st was the subsequent email stating how he could get the report, which is 8 days from the 23rd, which, if we were to even consider that.
All of which is within 14 days.
Within 10 days, even 14 days of extension.
Okay. So just to try to conclude here, what is the normal process by which someone can request and receive a police report? Can you just cover that for a moment?
Yes. So if a person requests an incident report, it's our policy to have that person to either come down to the Police Records Division, room 475, 850 Bryan Street, or they could request it also through a request form. They could fill out that information, mail it in, and then they'll be able to get that report, considering if it's not any exceptions, whether it be medical records that they're not involved with, and such. So it has a complete outline as well in the policy and the website.
So that form, which was in our packet somewhere, and I assume is on your website and generally available.
Yes.
I'm just having a problem. Maybe you can help me with this. How do you square that form and its particulars with the Sunshine Ordinance? Because it seems to me that in general terms, a police report is a public record. It may or may not be subject to disclosure depending on the particulars, but the report itself is a public record. So if someone just sends you a letter and says, hey, I'm looking for police report number 123456789 or CAD item number whatever, however you structure that, please send it to the following address. I'm happy to pay the fee. Or whatever, right, has that information. Do they still need to fill out the form? And how does that... Again, how does that form sort of square with the ordinance?
What I understand is that if a person requests the incident report, they fill out the paperwork, and then depending upon what report it is, for example, let's say it's a mental health detention report, that report will not be released to everybody regarding that circumstance because, once again, like we described, it's going to be unwarranted invasion of privacy on the person that was detained. So that specific person that was requesting it or the officer actually filling that request needs to find out who this person is. If it's not the person that's requesting it, they may or not release that information. And it depends, like I said, what kind of report it is. If it's a simple report regarding found property and is no crime that may affect anybody's privacy, and then that report may be released to the other parties as well. There is protocol regarding that, and it depends upon the circumstance of what kind of report it is.
And is that protocol in writing anywhere?
I don't know exactly for that.
Okay. I'm not sure that I want to pursue this further. I think that where I'm at with this, if there was it seems like there's no dispute that there is an incident report, and I'm not sure, I'll ask Mr. Garza in a moment, if he actually finally received it. Did you consider in responding to his request whether you could release a redacted version of the report to have some of the particulars but without any information that you considered an unwarranted invasion of privacy?
I considered that, and the issue that I have is that our policy forbids releasing the name and address of people involved, let's say a medical record regarding say mental health detention. Now, we must consider also in a police report or a medical record report, such as a mental health detention report, regarding other issues as well, such as the medication they may be taking.
Understood, but if that could all be redacted, right? Again, we haven't seen the report, so I don't know what's in it. I'm I mean, at some point, I think I'm also struggling with whether what you're calling a medical detention report, is that the term that you use?
Yes, that's a 5150 Welfare and Institutions Code.
Understood. If that's the same as a police incident report, and if in fact, it seems like it's not, but I don't know, and whether this sort of mental health report is actually a medical file within the meaning of 6254C, or if it's, in this case, a particular type of police incident report.
I could answer that. So a mental health detention report, incident report, is a police report, and it attached to it as well, or part of the process of that report, has a state form, which is the mental health detention report. So you have the incident report, police report, plus you have another state form regarding the circumstances of that detention. So in the incident report, I wouldn't be surprised if there is confidential information regarding the person being detained, such as medication being detained, circumstances of that person being detained, and also that state form where an officer fills out to have that individual being detained. Personal confidential information, medical record information would be on that as well. I wouldn't be surprised that it's commonly placed on there.
So do you know if the Welfare and Institutions Code makes that particular report, the detention report itself, a confidential record under state law?
I'm not sure.
Deputy City Attorney Cola, you know anything about that?
Sorry?
Do you know anything about that?
Could you repeat that report?
If the Welfare and Institutions Code makes that particular form, the mental health detention report, a confidential record under state law?
I'm not familiar off the
Okay.
top of my head with the Welfare and Institutions Code, but generally what I would say here is it's you could just use a reasonable person standard to determine whether or not there's a privacy exemption in a document.
Right. No, I understand the privacy interests generally.
In general, the task force might want to consider whether disclosure of the information would compromise substantial privacy interests, and must determine whether the potential harm to the privacy interests from disclosure outweigh the public interest in disclosure.
Understood. So, thank you. So back to my question about the redaction. Did you say that you considered redaction of the incident report or the mental health attached report?
Well, this was I wasn't at this unit at this time of the incident, but I'm
Did
gathering
Ms.
this
Conifrey or
information.
whoever was reviewing, somebody presumably looked at the report and said, we can't release this to this person, period. Did that person consider redaction of portions of the report and releasing a redacted version of that report?
I can't speak for Ms. Conifrey regarding what she thought. However, what I stated to you before that I thought about doing that, there's a lot of complications regarding that because of the numerous things that may be on that report, such as, like I said, medication, other issues regarding his circumstances of why he was detained in the first place. So it may not be like a simple procedure where you use blackout boxes. We're talking about stuff that...
Oh, it could be a heavily redacted report. I'm not
I understand
questioning that.
I understand that, but I'm not a doctor to analyze that regarding the condition of a person that is detained taking possible medication for a condition that they may or may not be suffering.
Why don't I defer? Maybe we'll come back.
Yeah, I just have one quick question.
Yes.
So, Lieutenant Woon, did you say that there is no written policy, or that you're not aware of a written policy at the police department for regarding?
I'm not sure of a specific policy regarding. Is it redacting?
No. About this whole the release of. I want to make sure I'm getting 5150 reports. Am I saying that correctly? The
mental health detention report?
Yes. Okay. Is there a written policy that explains what you have just come before us and explained, that you don't release it because it is in the interest of one's own privacy? Is that policy written anywhere?
There is policy stating regarding information that we can release and can't release on police reports, such as name, addresses from medical records regarding mental health detention reports. You can't release that information. But as I stated before, to get that information, there is a protocol that we do here in the police department, which is direct which we would direct.
I have no issue with the protocol or at all. My question is that protocol available to the public to read, that this is the protocol of the way that the police department deals with these
I'm
issues?
not sure about that.
Okay, well, I would, if it's not, or if you're not sure, I would highly encourage the police department to make that, to have written protocol
Thank you,
for
sir.
that, okay?
And if it is available, we'd like to see it, I
Yes.
think.
Member Oka?
Yes, thank you. Lieutenant, everything that I've heard so far makes sense, except that Mr. Garza here has said that he didn't mind his medical record being released. He said that right here. So why was he not given his own records? I would have done that immediately. They're his records.
Understood, sir. The response I have to that is that I have no response from Mr. Garza saying that it's okay to release the information in that fashion. And once again, we as a police department want to be as transparent as possible, but yet we have to protect his privacy rights. So if we were to release that incident report, that mental health detention report under the Public Records Act and Sunshine Ordinance, then we must release that report to everybody else that requested. Therefore, to protect his rights, we directed him to go to the records room, whereby we could satisfy his request to get that report and not violate his privacy rights in the future
Okay.
if someone else requests it.
May I ask Mr. Garza?
Don't go too far, Lieutenant.
Go ahead, sir, please.
You stated that you were not informed that that was the reason that you were being denied?
That is correct. In addition, I want you to know that everything that's been said by this officer has been a red herring. Because, for example, I was illegally 5150. The incident report, there is a 5150 manual on the police website. The 5150 was not valid. I was released within 2 hours. So to claim that, they're so concerned about my privacy and my medical condition when it wasn't even a valid 5150, which is why I'm trying to get these records, to show that this is what the police department does to people instead of trying to help them, because I'm here trying to follow up on my medical care, so they'll bully and intimidate me by falsely 5150ing me. Oh, and by the way, we don't have the videos. Oh, and while we're there, we don't have the policies that regard these videos.
Hold on a second.
But we do have the policies that regard, the exemption.
Member
Isn't that
Oka?
amazing?
Is your question being answered? I just want to stay on what your question was and get the answer.
That's all I needed to.
Okay, thank you.
So that is my point. You're being misled.
Okay. Come on back, Lieutenant. Anybody else got anything? What I'm getting out of this, and I spent hours going through this today, is the thing that struck me as a little odd is that if I want my own medical records, you're saying, no, I can't give it to you, but you can get it over here, right? You pointed our complainant over to another department or another group. Because what I'm getting on this is that if you release it, then boom, it's public and anybody can have that. And I get that. I wouldn't want my records being out there. But you didn't say no. You said, no, not from me, but from these people over here. I'm ridiculously oversimplifying this, but am I getting the gist of this? That those records were available through some other means, correct?
Yes, so through the initial IDR,
Right.
Mr. Garza requested the incident report, and Ms. Conifrey exempted that from disclosure under 1654C of the Government Code. However, she subsequently directed Mr. Garza to go to the record room and obtain it in that fashion so that his rights won't be violated.
So then what I have a feeling we're arguing about here is the amount of time, and perhaps Member Sims has something to ask or add.
Well, I guess I wanted to add, it just seems like there is some confusion about who the request was sent to, I think, and then the timeliness of the response. But when it comes to the response, part of the requirements in the Sunshine is that if we don't have this information, we tell you where you can get this information from. So essentially they're saying, we have it, but we can't release it because of this directly to you, but we can tell you exactly where you can go to get that record, which is part of what Sunshine was there for. I mean, they were very disclosing and very forthcoming in that. Now, the other issues regarding the filming and the, I don't know what real powers we have to, do our own internal investigation of were they telling the truth or were they not telling the truth. I mean, that happens in every single case of a public records request. We can only just hope that they have been completely forthcoming in all the records that they have. From my perspective, I don't see where they haven't been forthcoming. Except in the timeliness matter in the start.
That kind of stuck with me, too. You have something very quick, member Pilpil?
So
quickly?
Can you explain very briefly what gives the records management section, or whatever you called it, the CIS group, whatever they are called, the ability to provide records to the public that you're not able to provide under the Sunshine Ordinance?
It's policy that I understand that the Records Division takes care of the deliverance of police reports.
And where is that policy? Is that another policy that you don't have tonight?
Now, the policy, it was even on our website, how to obtain a police report. But I want to also address regarding the time issue that this gentleman was speaking, I'm sorry, Mr. David Sims, regarding the time incident. This first IDR that was sent was on the 21st, was a Saturday. Okay. We received it on that Monday. Ms. Conifrey sent a reply back to Mr. Garza on that same day, the 23rd, invoking an extension, and also responding back to Mr. Garza regarding the disclosure exempt from disclosure due to 6254C, the government code.
So if I can just follow up with Mr. Garza, because I've not talked to him yet.
Do you have something for Lieutenant? Or?
Well, not for Lieutenant, maybe from Pilpul. It does seem that, essentially, I think someone who's been essentially a quote unquote either accused of a crime or detained. Eventually they're going to have to turn those records over to that individual regarding, I guess, a mental health issue, because otherwise they can't go through the necessary due process without giving that to him. So I think that might have been the original reasoning why that process was created, to maintain the differences in their structure, in their own internal structure. I don't know. I wasn't there when it happened. Not that old.
And again, I think what we were asking earlier is if those policies exist in writing, I think we would like to see them, because there's some ambiguity that could be cleared up with understanding those written policies, whether it's policy or a DGO or whatever it is. Can I just go to Mr. Garza for a second? So between both of these complaints, what are there any records that you have not received that you requested at this time?
I honestly don't know, because I asked for, all other interagencies, if they communicate with other agencies. I don't know. I don't know what to believe, because as I've said before, this was a red herring. This was not even a valid 5150, and for them to bring up medical records, which it isn't, is a false lead. In addition...
Okay, did you ultimately get the incident report?
I did, but I don't know if that covers all the other interagency, stuff that was requested, sent, and everything else.
But you did get the incident report with the attached whatever detention report?
I'm not sure whether it included the detention report. I'd have to go back and look. I do know that I did go to file a follow-up report on it, because it was a false incident report. Because, like I said, I was released within 2 hours. Oh, and by the way, let's not forget that what Ms. Conifrey gave me, the information that you gave me, because you guys are just trying to overlook all this, was incorrect. It did not happen on the 19th. There was never any follow-up with that. There was never an admission. I was just constantly played. Oh, and you're correct. Even though there was 10 days for them to respond, I jumped through their hoop, and it probably took another 10 or 14 days after that, which is well over the IDR's 24-hour thing. Set to fail. Now, you keep asking about policies. When will you ask about the policies about the video cameras? Because they've said there's none.
That's a good point.
Okay, so I think you answered my question that you got all the documents that existed. And it,
Yeah. Okay.
that's all the information we have then.
All right.
Okay.
Do you have anything else? So,
Just for discussion, it seems like, yes, there was an extension filed, but I'm not questioning whether that was appropriate. If the answer was, well, we're going to redirect you to our regular policy of going over to this department to get this information, that should have been given right away. Why was an extension required? And they'd taken an additional 10 days to convey that information. That's starting to trouble me a little bit. If it was as simple as, well, this is how you should be able to get the information over here, that should have been part of the initial conversation that Ms. Conifrey had on September 23rd. What do you guys think about that? So I think it was, it could have been done better. It could have been communicated more clearly on the first day, and we probably wouldn't be here. That's just kind of my thoughts at this point.
okay, what happens next is, if we're done deliberating among the task force members, what happens next is the respondent, Lieutenant Woon or somebody else, you get 3 minutes to give us any rebuttals or conclusions or anything, and then...
Madam Chair, since this is a dual item, I would suggest 6 minutes per rebuttal.
I forgot about that. You may have 6 minutes to discuss this, and after that, the complainant will also be given 6 minutes.
6 minutes.
Up to 6 minutes.
I just want to reinstate that this was not a simple routine request that could be easily answered. As we saw here today in conference of talking about how we would try to gather this information or provide this information, is not a simple, readily accessible routine request that we could easily answer. This information that we obtained provided by Mr. Garza, actually, that he requested this information. It was thoroughly thought out, and we need to ensure that those privacy issues need to be dealt with and dealt with properly. We consider these requests quite seriously, but at the same time, we must understand that there are privacy rights that we must consider. So therefore, regarding the time constraints, I believe that it was proper within that time stance, because not only we must provide this information to Mr. Garza, but we must provide accurate information. There's no use of providing information that's not accurate. If we provide accurate information to him, then that's even more beneficial to him, obviously, and I think we owe that to the public for that. Thank you.
Thank you.
Thank you. Mr. Garza, you have up to 6 minutes.
Well, I love the mantra, we must provide him with accurate information. Did I receive that? As a matter of fact, the information I received from Ms. Conifrey was that this incident happened on the 19th, not the 18th. How accurate is that? After all their due diligence, after all their professionalism, after them knowing what the policies are when it comes to, delaying me in getting what I need. Was it voluminous? I think it was maybe 5-6 pages that I received on this incident report. Was it voluminous? They're worried about my privacy. Why didn't they send me to that place like you said initially, and why couldn't I have gotten it immediately then? Privacy? It's my privacy that we're talking about here. It's also an invasion of my rights when, they didn't even have any policies for their video cameras. Oh, and let's not forget the video camera that was behind the area that belonged to an individual while on duty that recorded me that they stated was erased. How dare they? That was performed, and that video shouldn't have been erased. Just because they've done wrong things doesn't mean that they should get away with it. You know, this professionalism that they keep wanting to tell you about and everything else and how professional they are. Well, why did Ms. Conifrey, as the most knowledgeable person, why is she not here? It's wonderful that Mr. Woon is channeling for Ms. Conifrey as opposed to what she might have thought, what she might not have thought. But, you know, to have already received incorrect information from her and for me to write her back and call her on it and say, well, now I'm demanding an apology and admission of this so that I can have faith in what you're sending me and trust you. Because it was incorrect, and to receive no follow-up and to continue to be played by their, shall we say, less than correct system. My God, they have a policy for how they release, you know, incident reports, but they don't have policies for their video cameras at the police stations? Huh? This is all a game. As a matter of fact, like I told you, every other police station I went to said that they did record. So where are those recordings, or where are the policies? You should be asking about those policies. That is very, very important, because do these cameras record or do they not? Have I been lied to? Now, like I said, in a post-9/11 terror world, Homeland Security, I'm pretty sure that if they got any federal funding, that these video recorders must record, as I was told, by the other police stations. But when Ms. Conifrey can send you something that's incorrect, not account for it, and somebody else can send you something and she can just whitewash it off and say, well, this is what I was sent, and not check on it, and then there's no policies, this stinks to high heaven. Beyond high heaven. You know? Now, the other thing, like I've said many, many times, you know, they keep bringing up that these are not my medical records. This was an incident report. My medical records, I sunshined the Department of Public Health, and no, I have not received them for this false 5150. I didn't receive my medical records when I went down and asked for the incident report number that he's claiming it was in my interest to protect my privacy. I didn't receive my medical records down there either. Don't be fooled. Don't be misled. Don't play into their game of look over here but not over here. Look at the complainant who is telling you that he filed a proper IDR. He got incorrect information. He followed up on it. He jumped through their hoops even though he didn't believe it was his responsibility. He continued to follow up and ask the appropriate questions and go in. Still couldn't get any help from this person when I went in. Those videos are on YouTube for me trying to follow up. And now this person's not here. Hoodwinked. Policies. Protocol. Excuse me, I'm truly not understanding any of this. You must remember, I went down to Northern Station to continue to follow up on the denial of my health care and reports that I was following up with. I was in no way, shape, or form confrontational, 5150 material. As a matter of fact, the videos would show that. My video that's on YouTube, you know, you don't even hear anything in the background of my video for them to claim these things. But you know, when they can fool everybody and say, hey, you know, this disabled person, you know, doesn't deserve the videos because we don't have any policies for that. But we sure do have policies for how he can go down and get the incident report that isn't even medical records, but yet tell him that you know, we can't allow him to get this because in the interest of his own privacy for medical records. Huh? Any port in the storm. Any port in the storm. Other than doing what's required, other than, you know, trying to be helpful and resolve it, other than finding an alternative, misrepresentation, misinformation, no accountability. I will repeat it for a third time. When I requested this information, she sent me that this happened on the 19th when it happened on the 18th. Truly reflective of the police department's due diligence.
Thank you.
Madam Chair?
Member Nee?
Yeah, I hate to drag these things out, particularly in the interests of timeliness of provision of records to a requester. However, I think we owe our thanks to Lieutenant Woon for coming here today. He's answered questions in as complete and forthright a manner as he could, but I don't think it's complete enough. There were questions he could not answer that he told us that perhaps Ms. Conifrey could answer. And I particularly, there was the question that Member Pilpel asked about why records could not have been provided in redacted fashion. I think that's a very vital question here, and I would like to. I'm going to move that this item be continued till the next task force meeting, and that Ms. Conifrey be asked here to answer the questions that Lieutenant Woon was not able to answer.
Mr. Clerk,
Chair,
did you have
Ms.
something?
Conifrey is no longer with the department.
Yeah.
Does that change things?
Well, yeah. Maybe not. Could I ask Lieutenant Woon back to the microphone, please? Is there any way that you could obtain the information that you were not able to provide today, either through contacting Ms. Conifrey and getting answers from her, or through contacting perhaps somebody else in her office?
Regarding specifically which information, sir?
Well, there was specifically a question of whether Mr. Garza was informed about the privacy issues on his medical information, and also the question of why the information, rather than being withheld, could not be provided to Mr. Garza in redacted form.
Do you know anything about that?
Please.
This is Sergeant Pedroza.
So, I was, some of the questions you have regarding the timeliness and all of this, I can't speak to, but I just want to try and clarify a little bit about the release of the police reports. I'm the supervisor at Police Legal, and I was Ms. Conifrey's supervisor at the time, and I'm still the supervisor at Police Legal. And like I said, I don't have a lot of specifics about this, but I know it for Mr. Garza's case, and for anybody here on the panel or anybody in the public's case, it's illegal for the police department. Not only we've been talking about protecting Mr. Garza, also protecting the police department. It's illegal under the Welfare and Institution Code to release a 5150 report to a person, even redacted. The records I have a unit of 14 people. Our records management is, I believe, 50 to 60 trained people on how to and when to release records. I believe that, and you can ask Mr. Garza this, but in order to obtain any record, because of HIPAA regulations and because of the Welfare and Institution Code, if you go down to the records room to receive your record, not only, I'm not sure if you have to sign a waiver or not, but I know you're ID'd. I know that ID is scanned and kept on record, so nobody, Joe Blow, can go down and say, hey, this is me with a fake ID, and get the record. Now, you would have to ask Mr. Garza. I've never had to get a medical record for myself from our records division. You would have to ask Mr. Garza if a waiver was signed and if an ID was presented. But my division and the police department in general, whether it be the chief's office or Police Legal or Lieutenant Woon or myself or Maureen Conifrey, can't provide anything lawfully under Welfare and Institution, even redacted, to anybody requesting a police report with any medical information inside. And a 5150 Welfare and Institution report does have medical information, no matter how minor it is.
Sergeant
Member
Pedroza,
Highland, you had something?
Sure.
I'm sorry, could you pronounce your name again?
Yeah, Pedroza, Pedroza.
Pedroza, Sergeant Pedroza. So it sounds to me that there is a pretty standard policy in place for these kind of requests, and you just cited it,
Well, the Welfare and Institution Code in general states that. I mean, I'm not being facetious. Yeah.
My question here is, why did Ms. Conifrey not present that information right at the beginning?
I almost kind of presented, I believe, from what Lieutenant Woon said, and he's the one that's been studying the documents, that Mr. Garza was directed to the records room, but even if it wasn't done right away, not exactly written, but...
So, just to refresh your memory,
Sure.
September 23rd, was the invocation
I
of the
don't know.
extension.
Probably.
And then October 1st, she presented that information to him.
Okay.
But it sounds to me, the more and more I hear, this is a pretty standard protocol. So
Yeah.
in the efforts of educating the public
Sure.
more efficiently, why would Ms. Conifrey or any of your reports not present that information right away?
I don't know
I'm just
when
trying to see,
yeah.
is there a standard?
I don't know when it was presented, but I'm almost, and I'm not trying to be facetious, I can't go out and rob somebody because it's state law. I don't have to be told that. So, and like I said, I'm not trying to be facetious.
Let me rephrase the question.
Yeah.
As Ms. Conifrey's supervisor, what guidance would you have given her for these kind of requests, or anyone, or her successor? Who's in?
Oh, well, she wouldn't. Yeah, she wouldn't need supervision for that. She would know. She would cite that reason. When it was cited, I don't know, but that's the research that the lieutenant's done. She wouldn't need guidance on how to do that because
pretty standard response.
She knows. Yeah, very standard.
And who's her successor?
Her successor right now, we have another legal assistant taking on her duties, but that only started 2 days ago, so it doesn't matter. But even that person knows that. I mean, it's kind of basic knowledge under welfare and institutions.
Well, thank you. Thank you for being here and answering these questions.
Where did we leave off? Member Nee, did you have anything else?
No. Was there a second to my motion?
Oh, you had a motion?
You did.
Oh, you
Yes,
did.
the motion was to continue, but if there's no second, it dies.
Okay. We'll consider that tied.
I follow up?
What?
Not on the motion. We're still on discussion.
Not really.
Well, I'm considering another motion.
Well, then go ahead.
Okay. So, to
Member
Lieutenant
Pilko?
Woon, I was looking in
Come on back.
the Welfare and Institutions Code and maybe Sergeant Pedroza. I'm trying to find the language that you referred to about incident reports being confidential. Do you know where I can find that in the Welfare and Institutions Code?
I wasn't referring to incident reports. I was referring to any medical conditions protected under HIPAA. Yeah, nothing for the San Francisco Police Department.
Okay, but I think you said that was
under
state law.
Yeah, under the Welfare and Institution Code, you're the only one who can obtain your own medical records.
And can you tell me where I can find that?
No, I have no idea. The code is way too large for me. Sorry.
Well, I mean, I'm in 5150 to 5154, and I'm not finding it specifically. So I guess what I'm stuck with right now is whether or not there was a violation for failure to provide a redacted copy of the police report, not the incident, not the detention report that we were just referring to, but the police report itself. It seems to me that a redacted, perhaps heavily redacted, version of the police report could have been provided under the Sunshine Ordinance. But I don't know. Is there any feeling among the members that that has any traction? Anybody? Nobody?
Anybody?
All right.
Okay.
Well, it depends on whether the request was for the incident report or the police report. If there was no request for the police report, then we're done. If there was and the incident report, according to the officers, is not releasable public information.
Right, although the reason for non-disclosure that was cited, the 6254C reason, is not this Welfare and Institutions Code reason, and that Welfare and Institutions Code section was not referred to in their justification for withholding. So either they needed to provide a heavily redacted version of the police report, or a better reason than 6254C for non-disclosure. And if there is a specific citation, that should have been provided under, what is it, 67.26, justification for withholding?
67.27, I believe. 67.26 is minimal withholding. 67.27 is justification.
27 is justification, that's correct. Right,
Might I state that a police report and an incident report are the same thing?
I'm not sure if that's true in this case.
Well, regardless, in his original IDR, he does say the police incident report. So I would tend to agree with Mr. Garza on that.
Okay.
So, hearing
Trying to
no-
make it as inclusive as possible.
Am I hearing any motions?
Still getting there, I think.
Madam Chair,
Member Nee?
I would say at the very least, we have possible violation of 67.21B or C. The immediacy questions aside, that's open to question, but
Do I have a second?
Well, just to add on to that, I mean, I like the fact that they were in touch, they responded, they continued to respond. He did ask for a lot, and when you throw in the video stuff, that's a whole other area. Perhaps that should have been, formulated as a separate IDR, and if they could have separated it, then they might have been able to respond more quickly. I still think that 6254C information was not delivered as quickly as it should have been, and that's the main problem I have here. I'm going to take a look to see if there's a motion that addresses that. But at the same time, I don't want to, punish the city department that did respond in a timely fashion, invoked an extension, because all that was good, and they did direct them to the correct area to get the information. So it's a tricky one here, and I think we need to maybe think about that a few more minutes before we conclude this.
Do we have a motion on the floor yet? I don't.
no, I haven't made a motion.
Okay.
I gave you some out loud
Yeah.
thoughts, but I haven't made a motion.
Okay.
So
Member Philpell,
why don't I try a motion, and we'll see.
why don't you?
It's almost like being emotional. To find a violation of 67.26, withholding of records, or, well, problem is it's either 67.26 or 27. So either the record, either a heavily redacted version of the police report, I think, should have been disclosed, or the justification for the withholding should have had more explanation than 6254C, which it sounds to me like doesn't necessarily apply, but it's probably a Welfare and Institutions Code reason. So I think either way, one way or the other, I think it appears to me that there may have been a violation. I'm having trouble as to which. Member Nee,
Does it have to be an either or? Couldn't it be both? 67.26 and 27.
Okay. I would need a second to clean this up. Okay, I heard a second.
Do you have all that, Mr. Clerk?
The motion is to find a violation of 67.26 and 67.27 for the withholding of records.
I'll second it.
I think we have a second already, right? So, shortly, we will have public comment on that. And look, the public is ready to comment. Do I have any public comment?
Thank you,
You have 3 minutes.
Acting Chair. I am speaking against this motion because it appeared from what I heard that the initial request was for the police incident report. There are other kinds of incident reports, like the ones generated in the department I work in. So tagging the word police in front of the word incident report doesn't sound to me like Mr. Garza asked for a police report. He asked for an incident report from the police department. And it sounds to me from what Sergeant Young? Lum? I didn't catch his name because of my hearing.
Lieutenant Woon?
Him.
Lieutenant
Yes,
Woon,
thank
yes.
you. Because of my hearing loss. Sounds to me like Mr. Garza was directed on the spot to an alternative location where he could have picked up the records the same day. He just appears not to have wanted to do that. So even though Mr. Pilpel is taking a real reach to find some citation in the Sunshine Ordinance to support Mr. Garza, I'm speaking against this motion. I don't think you should find willful failure or anything else against the police department, and I respectfully suggest that this matter should not be continued to some future meeting where you can quibble over this some more. Thank you.
Thank you.
Yes, before I start, I would like to quibble over 3 minutes versus 6 minutes on a double case. And I would like to ask for 6 minutes for public comment, since this is 2 cases being combined.
Let's stick with 3 minutes.
And that's one of the reasons why combining cases is a bad idea, because you get into discussions and arguments that take away from even the minimal time that you're allowing. This is something, as I said, that I have not followed with respect to looking at the record, but there were a number of points that seemed to me that I appreciated coming up, particularly by members of this body. So the first thing that I found pretty odd is that there was a record deleted, according to one of the officers, and that, I think, is very problematic. Is there such a thing as a private videotaping in a police station? I don't get that. What are the policies about that? And I do think there's a portion of the Sunshine Ordinance that references the destruction of records as opposed to the keeping of records in a proper way. So that I found very problematic. The second thing is, I think you've properly stated that even if every bit of content of a record were to be redacted, that record might still have value to the requester. And I can certainly give examples of that. What are the portions of the form? What are the elements of the form? What questions are asked or information has to be provided? Any number of things can be useful, and so it seems to me that, in fact, a redacted form needs to be provided with a full explanation. I was very troubled by the last-minute production, as I think at least one of your members was, by the last-minute introduction of a flat-out assertion that it's flat-out illegal to provide what was requested when that has not been put into the record before. I think you should also ask whether Ms. Conifrey is still working for the city and not whether she's not working for the police department, because if she is working for the city, I think you certainly have every reason to request her. Member Sims says he doesn't know the investigative powers of this body. I think Member Nee and other people who have a longer history do have an understanding, and it would be appropriate for you to ask for specific people to come, for specific laws to be cited, or for yourselves to do specific research. I think also that, to be fair to the complainant, you should discuss each and every violation section that he has cited and discuss why it should or should not be accepted in your motion. Thank you.
Thank you.
Thomas Piccarello. I'm strongly opposed to the motion. What I heard was the police department referred Mr. Garza to another department, in the police department, to get the records that he was seeking. Mr. Garza testified he doesn't remember if he went or not. And then Mr. Garza was asked, did he get the records? And Mr. Garza's testimony was he doesn't remember if he got the records that he requested. So there is no basis for the motion. And certainly there's no basis to continue this. So I strongly oppose the motion because the police department acted according to the Sunshine Ordinance, and they acted according to the California Public Records Act. In the remaining 2 minutes I have, though, I am troubled by the police department saying that if they give the record to Mr. Garza, they have to give it to the world. That's not the case. The case cited by Mr. Koma about the Black Panther Party didn't deal with medical records. It dealt with the debt collection agencies, where the court said if you give it to one, the records of a debt collection agency, you got to give it to everybody. That makes sense, but not medical records. Police department could have had Mr. Garza sign a release for his medical records, just to him and nobody else. And then they wouldn't have to give them to anybody else. I mean, that's what hospitals and doctors do on a medical record request. You limit it to whoever's requesting it and nobody else. But as to the motion, there's no basis. There's no violation by the police department of the Sunshine Ordinance or the California Public Records Act. Thank you.
Thank you.
Hi there, you guys. Mr. Kohler also cited another case, which is Los Angeles Police Department versus the Superior Court, and the person may be subject, who may be the subject of the particular records sought, does not, because he's personally effective, have any greater right than any person to examine the record. So there are other police departments who seem to follow the same procedure. And I'm against the motion on the floor. 6726, withholding of records, doesn't give a timeline. And Mr. Garza's testimony was vague. It was conflicting. He said he got some, but he doesn't remember what he got. So it really doesn't apply to me the way I look at it. And this second one, 6727, justification of withholding, it also doesn't say when they have to say, well, we're going to withhold it for these reasons. So maybe it didn't happen right away when he went up to the legal department. Maybe nobody told him, but they certainly directed him where to go. So they were helpful in that fact. So I don't think there's a basis for a motion. Thank you.
Thank you. Do I have any more public comment? Seeing none, let's.
Discussion on the motion? Or what?
I'd say we
Discussion on the
just.
motion?
Is there any more discussion, or should we just vote? Member Highland, you.
Well, I think the public brings up a couple of good points, and one of the things was that owner of the video device deleting it. I meant to bring that question up earlier. Perhaps Sergeant Pedrosa could answer that, what exactly that means. That's really, always thinking, but I'm not sure if we should continue. I would like to know where Ms. Conifrey is now working, if she's still a city employee. That's also a very valid question.
You don't know?
Perhaps our clerk can inform us on that.
No. Mr. Clerk,
I'm not aware
okay.
of her new position.
Okay.
I mean, regarding the deletion of the video, I think that we could obviously bring that officer in here to answer, but when it comes to public records, like, were there any public records created from deletion of that video? Yeah. The likelihood is not. I mean, if her captain told her delete the video, or she deleted the video herself, and it was an oral communication, no public record would be produced to record that incident. So I don't think that there would have been anything to give him under those circumstances. But it would be interesting to.
I mean, it's troubling that they actually.
It would be trouble. I mean, I don't know if an officer or a superior actually asked her to delete it, or she deleted it on her own, or if it was a male or female. Actually, I don't know all that.
Yeah. And if there's no video, they wouldn't have answered it. But the fact that they referred to it in their letter.
Yes. But I do want to say that 5150 is a voluminous, partly detailed, partly not detailed, of rights and responsibilities that the police are to follow, that the state are to follow, that the mental health institution is to follow, and it is a confusing code. So I don't think that we have this magic, let's look to the code and we'll get an answer about every incident. And I definitely don't think that, when it comes to certain, and obviously the issue with legal cases is all legal cases are never going to be directly on point. That's the, I think that's what we, as attorneys and lawyers, do all the time, is find the most relevant case and say, this is the most relevant case. It may not be quite on point, but it's similar and like. And I think, I don't know of any, and we don't have any information of any cases where 5150 and I think it's 5150, 5325.1, 5325, which also talks about certain rights and privileges, including the right to privacy of that individual who has been detained and sent for evaluation for 72 hours. So for me, at least, it's not enough here to go forward. But
and more I deliberate, I think I'm probably going to withdraw my second of the motion, because looking at an original request for information of a 10-day period, they did actually respond within 10 days, even though it was an IDR and an extension was invoked correctly or incorrectly. In the end, the complainant received his information in 10 days. I'd hate to punish the department for essentially doing the right thing. So as a second, I'm going to withdraw my second of the motion, if I can do that. Or do we just leave it and vote on it?
Well, we have to make a decision on that, actually.
I believe Member Highland is entitled to withdraw his second.
Okay, so right now we have a motion, but no second.
Is there a second on Member Pelpo's motion? I do not see a second.
Okay.
So
what?
I was just going to say maybe the part of the solution to this, if we're not going to find a violation, we could certainly take this up at the OT and discuss further with the police what their procedures are, how they handle incident reports, et cetera, et cetera. I mean, whether or not there was a violation, we haven't talked to the police in a while. It's nice to see them, but we could probably delve a little further into how incident reports are handled. So I would just offer that.
May I suggest that we take no action on this item, and we can create a hearing item to take up that matter?
And for what it's worth, I just found sections 5202 and 5328 that were part of what Member Sims was referring to. But they talk about services, so it is very unclear whether these are mental health treatment services.
So having said that, I, as chair, am going to declare the matter concluded. But I will take public comment.
Madam Chair,
yes.
you already had public comment when the motion was made.
When the motion was made, you don't need to take additional public comment.
Sorry, we already had that public comment. Thank you.
So item number 2 and 3 are concluded due to a lack of a motion.
And I will take this up at EOT, and we'll schedule it with the police. Thank you very much, Lieutenant Woon and Sergeant Petroza.
So, Mr. Clerk, I would like to, since it's already past 5 o'clock, I would like to move item 5 up first, public comment.
Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the Sunshine Ordinance Task Force's jurisdiction, but not on today's agenda.
Do I have any public comment?
Yes. You're looking right at him, ma'am.
My eyes.
So I am sticking to the discussion of public comment, and in passing, I'm going to mention your annual report because it was brought up in the context of the hearing last Thursday, at which the Rules Committee recommended 3 of you wrongly for reappointment. Todd David, as I testified last Thursday, has missed 46% of 13 meetings. The SOTF administrator should have reported Mr. David's absences long before I brought it to the Rules Committee's attention. You have a bylaws rule that you have to report absences in excess of 3 to the, I assume, the clerk of the board. That didn't happen. He's missed 6. Somebody's been asleep at the wheel again, administering this body. If you don't know, let me be the first to inform you. Your predecessor, Hope Chair, who is by far the best chair of this body in years, filed a complaint today with your body over the Rules Committee sending those 3 referrals to the full board. She asked David Chu and Angela Camillo this morning to send it right back to Rules where it belongs. If they don't do that by tomorrow, I have every intention of filing an ethics complaint over Rules mistakenly forgetting to include a disabled member. You recall the same issue that killed Sunshine for 4.5 months in 2012. Chair Grant disappointed the crap out of me last Thursday when she said that you had an extra meeting a month. You don't, folks. You've always had subcommittee meetings, and they don't count. Looking at your agendas posted online, I could find 4 extra meetings in a given month, 3 of which were canceled. You've held 1 extra meeting. Doesn't count in the efficiency matrix, nor does artificially withholding putting only 5 matters on your agendas. That's not efficiency. That's you wanting to get out of here early at night, which, according to your minutes, you've done admirably at getting out at 8:30, 9 o'clock, 9:30. The 3 of you should withdraw your request to be reappointed. You're inefficient and you're incompetent.
Thank you. Do I have any more public comment on anything not on today's agenda?
Not on today's agenda. Hi, how are you? You know, I've had a lot of problems with the Arts Commission. There was a street artist committee meeting last week. They don't happen very often, 6 a year maybe. And there's a new chair there. An older person who's served under 4 mayors and been off and on with the commission for 25 years. So I was having good hope that things were going to change. And I actually went up the next day and bought the permit. So I went out to Justin Herman Plaza. You have to do a lottery at 6 o'clock in the morning. By 9:30, the market manager was all up in my face. I said nothing. I just videotaped him, calling me a criminal. I belong in prison. He's going to run me out of the program. I already have 6 violations on me. And he's laughing and joking. That was about 9:30. About 10:15, he came back and he pointed to a cop and he said, "See, Richard, he's my friend. He's going to file fake police reports on you, and you're going to be called a threat to public safety." That I also said nothing and videotaped. I looked in the minutes of previous street artist meetings, and this Richard Ernest is out of the southern station. Justin Herman Plaza is the jurisdiction of Central Station. So I spoke with the CEO today, and tomorrow I'm turning in this permit. I have no idea what's going on in that program. It seems extremely bizarre, extremely nutty, and I just wanted to let you know I tried. That's it.
Thank you. Do I have any other public comment?
Yes. Peter Warfield, Executive Director of Library Users Association. The Rules Committee on Thursday did a shameful thing with 13 applications for all 11 seats, which are now filled with all holdovers. They only appointed...
Please, some silence in the audience. Thank you.
I think that's correct. There are not 11 holdovers, but basically anybody serving currently is a holdover and has been since the middle of April. So they only approved 3 of the members who have applied for reappointment. That is a vote of non-confidence in basically democracy and in sunshine, particularly since the first 5 seats had really excellent and strong candidates. There was an attorney from Electronic Frontier Foundation for seat 1. I believe Ms. Washburn, who's not here yet, brought a current or former president of the League of Women Voters, and again was turned down for reappointment. The appointments did not include somebody as required by Sunshine who is physically disabled. And so it will be very interesting what happens with the complaint filed by former chair Hope Johnson with regard to that requirement, as well as the fact that the agenda did not show that there was a requirement and is a requirement that at all times this group have serving on it somebody physically disabled. There's a whole range of issues that one could discuss, including an unfortunate report from the former chair, who apparently is not requesting reappointment, apparently stating a good deal of what's in what appears to be this draft annual report. And chief among those things that she said there was nothing, absolutely nothing, about the outcomes of public complaints, but essentially a trashing, an implied trashing of complainants who have the nerve to file complaints more than once. In fact, apparently too much. That's just the beginning of what's wrong with the attitudes, and there's more to come later, I guess.
Good afternoon again. My problem here is the way the task force is handling the complaints, in the sense that I think there can be a lot less discussion. I understand your concern to give everybody their due process rights. On the other hand, I think you're going to need to tighten up the discussions so that you can hear some complaints on a timely basis. My reading of the Sunshine Ordinance is the 45 days is mandatory. So in theory, either side that loses one of your hearings after the 45 days can argue that, your order of determination or lack thereof is null and void because you've gone beyond the 45 days. So I think you need to focus on the 45-day rule, and in order to achieve that, you not only have to consolidate cases, but you have to shorten the discussions when you deliberate on cases. You know, just because you give somebody 6 minutes, you don't have to allow them to talk 6 minutes. If he says or she says something that on its face, there is no basis for the complaint, I think you can shut them down without having to hear 25 minutes of meaningless discussion that's not reflected on the merits. So I urge you to spend less time on each case. It's not fair to the complainants behind me to have to wait until 9 o'clock tonight to have their cases heard, nor is it fair to the 40 other complaints that aren't even on your agenda, that are past the 45-day rule. That's mandatory. Thank you.
Thank you.
Okay.
Is he allowed to speak?
Why would I not? Is this
Sorry,
not public
come on up,
comment?
General. Okay, go ahead.
Amazing. Simply amazing. Well, I'm here to do my usual. Unfortunately, I've had another dreadful experience at the Ministry of Sunshine. You know, informing everybody that I never received the policies which I requested. You know, informing everybody that I never received the videos. One video was deleted. But everything that I want.
Speak on cases that are on today, that were heard today.
I'm speaking in general, thank you. Then also, the reason I'm bringing all these things up is because this is the Ministry of Sunshine, which is supposed to be sat by 11 people. We had a person priorly tell us that the nuclear winter had lasted for 4 months in 2012, and we couldn't even get 11 people sat between 2012 and April of this year by the Rules Committee. Now, we've had other people come up in public comment and state that, you know, there's 8 holdovers. The question is, will this ever be sat appropriately? Now, mind you, I went in and I saw the administrator and I spoke with Angela regarding all of this, and I was told to get to the bottom of it to find out why the nuclear winter was closed, why the whole thing wasn't sat properly, everything else. When I went to follow up, and those videos are on YouTube also, I wasn't assisted with it. So basically, at this point, I'm still trying to follow up because I want to post this on YouTube for people to understand that even 2 years later, the Rules Committee still has not done the correct thing. It didn't do the correct thing for 2 whole years. There was never 11 members here, which would facilitate the 6 votes that are needed, which has denied everybody in due process, and exactly what the prior person said about it going on for longer than 45 days. I have another case in front of you, which I will show that the Ministry of Sunshine is a total farce because there is no precedent. It's going to be about medical records. It's going to be about being denied medical records. Now, mind you, they're not even totally sat, nor appropriately sat. Another interesting question is, everybody keeps bringing up this thing about the disabled person on the task force. Well, as Mr. Wolf will inform you guys, if you do decide to ask him, the disabled person here is a token. He is not here for the disabled community. When I specifically asked Mr. Wolf whether he could be my disability representative on this task force, I was sent information by, I believe it was the prior deputy city attorney, that said that was not their role. They're simply just disabled. They're a token, but they're not here for disability rights. So I just wanted to clear that up in addition. Thank you for once again being the Ministry of Sunshine, obscuring things, not looking at what's correct, avoiding the fact that there are no policies for video retention at the police department, which allows them to delete my video, that was directed at me behind the window by the person, to not bring that person in. You've not disappointed me. You've just done more of the same.
Thank you. Do I have any more public comment? Okay, seeing none, I will.
Madam Chair,
Yes,
could we request a brief break, please?
I want to conclude public comment first. Seeing none, I declare public comment concluded. Would you like to take a break now?
Yes, please.
Okay, I have 6:04. Let's be back here at 6:14.
I might change my mind and submit an application.
All right.
That's true.
Okay. Okay, I'm going to declare this meeting back in session. Mr. Clerk, can you read the next item, please?
Item number 4, file number 14005, complaint filed by Jason Grant Garza against the Department of Public Health for allegedly violating the Sunshine Ordinance Section 67.21, 67.25, 67.26, and 67.27 by failing to adequately respond to immediate disclosure requests made on September 21st in regards to the medical screening examination report and other related documents.
What?
We have Mr. Garza. Do we have someone from the Health Department?
Yes, it's all
Okay.
taken care of. So what's going to happen now is Mr. Garza is going to get 5 minutes.
Point of order.
I was going to find jurisdiction.
What?
Jurisdiction.
First, we're going to find jurisdiction.
So moved.
Second.
Do I have a second? Okay.
Is that without objection?
Public comment on
Public
jurisdiction.
comment. Do I have any public comment specifically on the jurisdiction of this case? Seeing none, let's continue. Do I have 6? Yes, I do have, for the record, I do have 6. Can I pass that without objection? Okay, so we have jurisdiction in this case. So now what we're going to do is the complainant is going to get 5 minutes, and then respondent from Public Health back there, you're going to come up here, and we're going to give you 5 minutes to make your case, and then we're going to discuss it, and we're going to go from there. And you will get another 3 minutes at the end, each of you, to conclude your remarks. So we'll start with the complainant.
Okay, once again, my name is Jason Grant Garza, and I'm here to file this complaint against the Department of Public Health. I was illegally 5150'd at Northern Station, and I requested the medical records from San Francisco General through the Department of Public Health, which is over San Francisco General. Some interesting things that I want to bring up is that I want to prove to you today that the Department of Public Health is a serial violator, that, you know, there is no precedent here at the Ministry of Sunshine, that I have brought them before you guys many times in regard to my own medical records, and that there's never been any precedent set so that they can continue to deny and force complainants to reinvent the wheel. And I have specific examples. So, for example, here is an order of determination in 2002 saying that the Sheriff's Department failed to provide me my medical records. Because in 2002, I had been, I had written to them also. Okay, then there was another violation in 2010 where Mrs. Shields was sent up because I had requested medical records, and of course Mrs. Shields informed the task force that she wouldn't be at the hearing, what happened was that official misconduct was sent up to ethics, and of course ethics did nothing about it. So what we have, and what I'm trying to show, is that it just continues to happen over and over and over again. First of all, my medical records are public documents. Let me read off what I requested and what happened. Okay. Oh, I'm sorry. In addition, also, I want to state that the last time that Mrs. Shields and everything that I had to get my medical records, they had basically stated that I had to sign a HIPAA release form to get those medical records. Okay. Last time they were in, and I believe it was case 11081, where they said I had to sign to receive my medical records. The privacy information person, Mrs. Gleghorn, got up and testified that I had to sign to receive my medical records. I had to sign the HIPAA release form. These are not public documents, is what it's stated basically, and I believe that's what Mrs. Shields sent me. I went ahead and wrote her back and said yes, they were, and I informed her that Ms. Gleghorn and the HIPAA expert had gotten up and testified that I had to sign a release form. Then, after it got all waylaid and everything, Mrs. Gleghorn writes me back, and please note right here, I received your email of 4/25/2012. I am aware that you have not followed up on receiving Dr. Pache's multiple offers to provide a copy of the records that you're seeking. I am proposing, as a privacy officer, very, very important, right here, to provide you with your records. I'm sorry, to provide you with your records. I have consulted with the city attorney, who is in agreement that I may provide you with your records directly, without having to sign a HIPAA release form. To which I wrote her back and specifically stated, Ms. Gleghorn, you know, this is like padding the file. Did you send this information to the Sunshine Task Force, where you had gotten up and testified that I did have to sign this HIPAA release form? You know, and I told her, please, I do not want to be provided with something that is not provided by law, or as you put it, an alternative. Naturally, the task force never brought this up because this was during the nuclear winter. You know, the repeat serial violators got to do it all over again. I believe this has also been included in my packet on this case for you guys to have reviewed. Now, this last IDR that I sent in, I was told that they're not public records, once again, and that I would have to sign a HIPAA release form. As a matter of fact, they sent me down to San Francisco General. When I went to San Francisco General, I, of course, videotaped that. And, of course, when I pulled out the law and showed them the law, of course, I was only wrong while I was right. So if there's any questions that you want to ask me, I'm more than happy to go. The last quick thing, 14 times you guys have failed when you sent stuff up to ethics. I expect this to be another.
Okay, thank you. Can we now hear from the respondent, please?
Point of order.
Yeah.
Facts and evidence.
Oh, sorry, guys. Do we have anybody out there who wants to put any facts and evidence for this complainant? Seeing none, I'm going to ask the respondent to come on up. See, I already did it in my head. Somebody else out there.
Good evening. I'm Dr. Alice Gleghorn, and I'm the privacy officer for the Department of Public Health. Okay. Actually, I'm the privacy officer for anything that's not a hospital. So there are separate privacy officers for San Francisco General and for Laguna Honda Hospital. Okay. I've been advised that the current complaint is the same as the prior complaint, which was resolved about 2 years ago. Mr. Garza made a public records request for his medical records. He was advised that medical records are not public records. We appeared before the Sunshine Ordinance Task Force, advised him again that these were not public records, and advised him how to attain his medical records. Typically, anyone who would like to obtain a copy of their medical records is required to go to the facility where they received medical care and file that request with the medical records department. We need to track who is making requests, and if you're requesting it go to somebody else, that needs to be clearly written out. So the typical way to get medical records is to file that form and sign the request. We can make accommodations if people refuse to sign the form. We can document if this is truly the person in front of us. We can document that the request was made and then satisfy the request, noting that refusal was to sign the record. So, but typically people go to the medical records department, file the request, and get their records or arrange to have them sent to another party. Okay. Part of the form that is signed includes the information that the person is to read through and understand. I recognize that if I am disclosing my health information to someone who is not legally required to keep it confidential, it may be redisclosed and may no longer be protected. I bring that up simply because I want to be clear why we don't bring medical records into a public records request. If we were to give records over in this environment, then those records would be part of any future public records requests involving the activities of this group. So that is why we don't disclose private medical records in a public forum. Okay. 2 years ago, the task force made the determination that Mr. Garza could receive his medical records in the normal way. We made arrangements to have those records ready, available for him at the clinic that he had visited. And there were a number of communications advising him that the records were available. All he needed to do was go and pick them up. He never appeared asking for his records at the clinic, and the records were still waiting there when I was advised that this complaint came in. I was not aware that there were any other medical services for him in the past couple of years. I was not aware that anything happened with the police department that then resulted in a medical record. It sounds like perhaps at San Francisco General Hospital. If he wants those medical records, the process would be the same. He would need to go to the medical records department at San Francisco General and make the request for those records, and those records could be obtained. So I don't really have anything further to add. This information is part of the Sunshine Task Force minutes, from what I understand, from 2 years ago, and nothing has really changed. This is essentially the same request that was resolved already.
Okay, do I have any members of the public that would like to introduce facts or evidence in support of our respondent? Seeing none, I'm going to open it up to the task force to concisely discuss this with both the amongst ourselves and ask any questions to the complainant and the respondent. I'm going to start. Dr. Cleghorn, my question's really quick. You're not at the general. You're at administrative.
No.
Where, are you at Waddell, or are you're?
No, I'm part of the Department of Public Health Administration. Actually, I have several.
1380?
Yes, I'm at 1380. I have several other roles that don't involve privacy at all. So I'm the county alcohol and drug administrator, and I have other things that I am part of.
Okay, I was just trying to place you in.
So I live at 1380.
Okay,
Howard.
I am going to open this up to my member Nee.
Mr. Garza, please.
Yeah, don't go far, Doctor.
Yes, please.
Okay.
We've heard that when you made the record request to the health department, you were directed to San Francisco General. Did you go to San Francisco General?
Yes, there's plenty of videos on YouTube where I went and asked.
Okay, and what happened when you went to San Francisco General?
I was misquoted the law. I was told I had to sign a HIPAA release form like I was by Ms. Gleghorn here, way back 2 years ago, which she, of course, is conveniently admitted that this happened 2 years ago. And she doesn't speak to the fact that, there's allowances where I don't have to sign. And now let's not forget, she's not the person who's the most knowledgeable here to represent the hospital, according to her. She's only here to represent the Department of Public Health and the clinics, not the hospital. So yes, I did go to the hospital. I did ask. I don't have to sign a HIPAA release form. As a matter of fact, I didn't have to sign one back in 2002 when you guys, agreed that, my medical records were public records. But you split off this case to look for a HIPAA expert who never showed up to agree with me that that it was not required.
I have one additional question.
Please.
Why is the Department of Public Health named as your respondent rather than San Francisco General Hospital?
Because the Department of Public Health is over San Francisco General. They run San Francisco General. I sunshine the correct person.
Thank you.
Anybody else? Oh, you were next. I'm sorry, Member Pilpil.
So, Ms. Gleghorn? Doctor, excuse me. All right, so you're with CBHS, right?
One of my roles is
Okay.
in
You do all
part
kinds
of
of things.
CB.
One of the
Yes.
things- okay.
My privacy role is over everything that's not a hospital.
Got it. Ms. Sarrier apparently sent us a communication. Is she the new PIO that replaced
She
Ms.
actually is
Shields?
not the new PIO. My understanding is that there's a new PIO in training.
Okay, so she
Ms.
was-
Shields retired.
Last year.
Yeah.
That
Some
was a,
point.
that
I don't
was a
remember
fun
how many
retirement
months
party,
ago.
though. I remember that one.
Okay.
Okay. So Ms. Sarrier is the interim person who's handling.
She is receiving those communications.
Okay. So you said that you're the privacy officer for the clinics, and there are additional individuals for General and Laguna
Yes.
Honda.
Yes.
Who is the privacy officer for General?
For General, it's Maggie Rykowski.
Okay. And is Ms. Rykowski, is that correct? Is she under the same privacy understandings that you are?
Absolutely. We have
Okay.
one set of privacy policies that applies across everything that's DPH and that all of our contracts are also need to follow. Although the hospitals might put their logo on a specific document, it's the same set of policies. And
Okay.
the way we handle the way we notify clients of their privacy rights is through a HIPAA notice of privacy practices that's given to everyone when they come and consent for services, and that's also available online.
Okay. So I think I'm clear on that.
Okay.
So to Mr. Garza, are you familiar with the individual who was mentioned at SF General, or have you followed their procedures to obtain your medical records?
For the second time, I have plenty of videos on YouTube of me going in, speaking with Philip Katzenberger, requesting, my medical records legally the way I'm allowed to. I told him that I had sunshined the Department of Public Health for my medical records. He informed me that I had to sign a HIPAA release form, which was incorrect. I took the HIPAA law with me, pointed out where it was incorrect, never got a response. Now, mind you, this is something that's very important for you people to look at. Yes, you did. This is what I received on the 14th, which was 2 days past the deadline. Everything was supposed to have been submitted by the 12th. I submitted all my stuff by the 12th. In this, it says that basically the Department of Public Health, his failure to provide information and details that have not already been heard by this meeting group violates the due process of the Department of Public Health. They're trying to say precedent.
Okay. That wasn't my question to you. My question was whether you've gone to SF General and
Yes.
have you obtained the
No, of
medical
course not.
records
I've
that
been
you should?
denied. Of course not, because they're insisting that I have to sign a HIPAA release form, which is exactly what Ms. Claiborne said, which he just admitted that all the policies are the same under the Department of Public Health for the clinics and the hospital. They follow the same procedures, and yet Ms. Gleghorn, in the paperwork I showed you earlier, was willing to make an accommodation.
Right. So are you unwilling to sign the appropriate release to get the documents?
Sir, your phrasing is incorrect. I do not have to sign. They are not the proper documents. HIPAA, PHI was written for my control,
Right.
not their control.
So are you unwilling to sign a release in order to receive the documents?
I do not have to sign a release. Under HIPAA Section 1, I have the law right here. So before we go on that wild tangent that you're making, I do not have to sign a HIPAA release. This is what I took in to Philip Katzenberger. This is what I brought to you guys last time. 164-524 says I can request my medical records written or show up and request them orally, and I did write them, through my sunshine request.
Do you have a subsection there?
Yes, 164-524.
Do you have a subsection of 524? It's a long code section.
Well, it's probably the very first one, A, B, or C. I mean, it's very implicit. I'm just trying to find where it is because
we have that in our packet, but it's a rather complicated section of federal regulations.
Right there, it is number, hold on a second. I got to put my glasses on, I'm an old man. It is number 1, right to access. Except as otherwise provided in paragraph A2 or A3 of this section, an individual has a right of access to inspect and obtain a copy of the protected health information about his individual designated set as long as the protected information is, so there you go. I'm entitled. So, this begs the question as to why Ms. Gleghorn, made this accommodation supposedly. And I said, I'm not going to do this until we go to Sunshine and you explain to them that you lied to them. That's why I didn't go pick up my records. Because this was in 2012, probably while you guys were closed down.
Okay, I think I'm good with that. So
Thank
back
you.
to Dr. Gleghorn. If Mr. Garza is unwilling to sign the requested release, if these were records that you held, you would make a note to the file as you indicated?
Yes, and he's
disclose
been
them?
told that.
Okay.
I want to say that this is a very unusual circumstance.
Yes.
Typically, people fill out the request. They're very careful noting what they want included or not, and they sign the form, and that's the document. It goes in the chart. It's extremely rare that someone would make a demand for records and then not write that is what they want. Because the request is in writing, I was advised by the city attorney that we could go ahead and comply with the request if he came and I documented that he was refusing to sign. They would accept that as
in lieu of the signature.
In lieu of the signature, but it's highly unusual, and I wouldn't be surprised if other medical records departments, and indeed every clinic has their own medical records department, would not respond to that kind of request because it's so atypical and unusual.
Would your colleague, whose name I'm already forgetting, at SF General, apply under these circumstances the same principle, identify Mr. Garza as Mr. Garza, make a note to the file, reference the written request, and disclose the documents? Would that be the normal course of affairs?
Well, no,
or-
the privacy officer typically wouldn't be involved at all in this.
medical records?
It's medical records. You go to medical records, you complete the form, you turn it in, you get your records.
Okay.
And indeed, his records from 2 years ago have been waiting for him at the clinic.
And still are. But the records at issue in this complaint relative to this particular incident,
I wasn't aware there were records at San Francisco General, but we could certainly communicate with medical records if I knew if this was an inpatient, or I have no idea what
as we
what
heard
was
in the earlier
involved.
case, it sounds like it was.
I didn't really. I thought it was all a police thing. I didn't realize it was involved the hospital at all. So.
I think, as I'm interpreting, that it was a 5150 issue that may have resulted in a trip to general, but I don't know that for a fact.
So emergency room or PES or something like that. Okay.
I don't
yeah.
even. What is PES? That was referred
Psych
to.
emergency
Psychiatric
services.
emergency services.
They would
I'm
typically
pleased to
hear
say I've
a
never had to
5150.
be
Yeah.
involved in that.
Yeah,
Thank
I
you.
know
Yeah.
it well.
Sorry about that.
Not for me.
But we really would like to accommodate his request. We just haven't had the follow through in the last 2 years for the records that he'd requested previously. And as I say, I was unaware that there was another admission.
I guess it sounds to me like it's not really a public records issue, it's a medical records issue.
That's right.
That's properly handled under HIPAA pursuant to the regs that DPH
Thank
has.
you. Anything else? Member Nee, you have that mouth agape look.
Well, I have no further questions for either side, so
Okay, member.
for the moment, I'm good.
Member Sims and David? You're looking, not you. You're looking quiz. I'm looking to the right side of this table.
I'm just trying to clarify whether, because I do agree that it does entail HIPAA, and obviously, I mean, while the Sunshine Ordinance does cover the city, I mean, as we well know, federal law trumps state law, in state ordinances and local ordinances as well. However, the question is whether, to what extent, we are charged with enforcing. But I disagree when it comes to the statement that the issue is solely HIPAA regarding us and public records, because it sounds like it is a type of record. It may not be public per se, but it is. I mean, it is about access to the records. And he should be getting that access. He's a member of the public getting access to records that were produced in the public sphere. That makes it a public record, whether it's exempted from being produced to all to see. It's an exemption, and then he can get it himself.
But if
Here's what I'm saying?
Yeah, but if the department explained to the complainant how to receive the records, and they did so on a timely basis.
No, I agree. They did so. I think they did so on a timely basis from the last time he was here. It sounds like this second time regarding SF General Hospital, if we are to believe the circumstances occurred as they occurred, right? Maybe the person in the medical records was not following the policy with releasing the public records without signing the HIPAA declaration. What she has said is basically I'm sorry, I didn't mean to call you she. Dr.
Okay. Dr. Gleghorn. Yeah.
Gleghorn?
Gleghorn.
Gleghorn. Okay. I'm gonna doctor.
Think of foghorn, leghorn with
the G in front.
What
Exactly.
you said is your policy, and I'm not trying to belabor this, but what you said is your policy. So it sounds like there's a lack of policy being funneled down and either written in some type of format for the medical record staff of all the clinics and facilities under the Department of Public Health, right?
All of the clinics follow the same policies, and the typical 99% of the cases would be to fill this out and sign it.
Do they know about that 1% exception, which is his policy, which is his issue?
No, because it typically wouldn't be done under normal circumstances. I mean, we only entered into this on the advice of the city attorney following the visit to the Sunshine Task Force. Yeah.
And I think to me, I actually don't even know if this whole incident is itself a violation, or is this something that needs to go to education, outreach, and training or compliance so that we can make sure that the 1% policy gets out to all of the entities that are under the Department of Public Health.
Well, the policy also includes in training for all DPH staff that if they have any questions or concerns, they're supposed to contact their privacy officer.
Yeah.
So the privacy officers are aware of this and could give the answer if the staff.
If the staff contacts.
I'm just trying to make the point that it is so unusual for anything like this to happen.
Yeah.
I think people, they have their instructions. They follow their instructions.
Yeah.
I'd just like to bring it to the attention of the task force, page 227 of your packet. There is a italicized and bold portion that actually paraphrases part of HIPAA, and it seems that the policy was actually based on codified federal law.
Thank you.
Stating that including a signature for the medical records at issue is within the confines of the law.
Okay.
Third paragraph down. Okay. Well, do I have any other comments, questions from the task force? Hearing none, I'm just going to, Member Oka, you're good back there?
Yes, I'd like to ask, Mr. Garza, when you went to General and asked for your records and were told to fill out a form and sign, and you said you didn't have to, what was their response?
The director of HIS, Health Information Systems, Philip Katzenberger, told me I was wrong. One thing I want to point out to you people, this is from Mrs. Shields in 2010, where she states that giving me my medical records without signing HIPAA violates everything. There's no 1% here. There's no nothing here. When Ms. Gleghorn got up here and testified, priorly and everything, she didn't testify that she had sent me the alternative later on and that she had lied to you guys and said that I couldn't receive all these things 2 years ago. She's never copped to that. You've never asked her about that. Right here is a contradiction. This young man just brought up about a signature. Last time we had this discussion, Mr. Nee, 2 years ago, we discussed about the signature on my email IDR and that was a signature. Now they're going to bring up Section 508 about releasing my medical information. Excuse me, Section 508 is to other people, not for releasing the information to myself. The privacy clause is for me. I don't have to be worried about keeping things private for myself. I do not have to sign the HIPAA form. You've been misled, misdirected. Could I answer another question for you, Mr. Oka?
It seems to me that given that Dr. Leghorn has said that you do not have to sign the form, but it seems to me that the records are there for you to.
But, sir, this is the first time she said it. 2 years ago, she said I had to sign the form, and then when you guys ended this case and split it off for the HIPAA expert, then she writes me afterwards, in which I wrote to her, no, we've got to go back in front of Sunshine to get this straightened out. Let's not forget this key, important issue. You're being played.
Thank you. Do I have a motion from anyone?
Rebuttals?
Darn it. Okay, so now we're going to go into rebuttals, and the respondent is going to go first, and you get 3 minutes for rebuttals or any conclusions or anything else, Dr. Gleghorn, that you want to share with us, and then we will hear from the complainant, who will also get 3 minutes for rebuttals and conclusions.
I'll just summarize that medical records are not public records. They are not releasable through a public records request. They are releasable when you file a specific request for your own medical records. And the form, which is based on federal law, does have a signature line. And the typical process is that the form is completed and the client is served. We have, because of the work coming here to the Sunshine Task Force, we have tried to accommodate Mr. Garza's requests. We have offered him to have it available. I've been advised that we can document that he refuses to sign, but we verified that it's him requesting the records. Really asking for a signature is to protect the client and to have a document that shows you made the request. So in waiving that right, we could document that he refused to sign and give him the records. The records are available through Medical Records Department, where service was received, and we're happy to accommodate those requests, and I'm happy to answer any other questions.
Thank you. Okay, so now we'll hear from the complainant. Mr. Garza, you have 3
Well, I certainly hope that, if the records are available, that she will be available to explain to Sunshine why she had misled Sunshine 2 years ago. Also, if the records are available, does that mean that I can go down to San Francisco General, not sign anything, and pick up my records? I'd like for her to answer that question. What does available mean? Priorly, she said that the records had been made available to me, if I would sign the HIPAA release form. Apparently that wasn't correct. So what do her words mean? I truly do not know at this point. I do know that I do not have to sign a HIPAA release form, and that's incorrect. I do know that you've been lied to and misled in the past, and now all of a sudden, there's this gracious allowance on their part, which they've never explained to the Sunshine Task Force why this was allowed to happen in the first place. Now, she gets up here and she says, they're so willing to help me. Well, Jesus, I've got 3 or 4 videos on YouTube of me going to San Francisco General. Apparently I wasn't helped. I've also, got this response to her from 2 years ago, which she's never responded to. The letter that I showed you asking her to come back in front of Sunshine so that we could clear this HIPAA issue up, she never responded to. In all her glory, as a doctor, to do no harm. I'm being harmed. I'm being lied to. I've been correct all along. You guys in the past have found that, yes, one's own medical records are public documents. This is the thing I tell you about precedent. So again, you'll find that they're public documents. Again, you'll find that I'm entitled to them. But there'll be no precedent. You might send them up to ethics who won't do anything. And then next year when this happens to me, I'll have to reinvent the whole wheel all over again because they'll once again say, guess what, Mr. Garza? Your records aren't public records. It's worked for them in the past. It's worked for the last 10 years, and it's still working. Nobody's asking them the important questions here. Are they public records? Yes. We all know that. Am I entitled to my own private public records? Yes. Did I do everything that was required through Sunshine? Yes. Does this violate HIPAA? No, she just said it didn't because all I had to do, like I said all along, is request them writtenly, which I did through Sunshine, the Department of Public Health, or show up with my ID and request them, and I did all that. That's all on video on YouTube, So please, please don't disappoint me once again. And make sure that when you make this ruling, that there's a precedent set. So that when anybody in the future asks for their medical records under Sunshine, they won't be denied. Now, someone else's, of course, deny it. But your own medical records, which you have control over, to be denied and to have to sign for? How am I invading my own privacy?
Thank you. Ladies and wait a minute, gentlemen only of the task force. Apparently I'm the only lady today. Apparently. That was a bit of a problem the other day. Well, hearing no motions.
Madam Chair.
Bring it home, Member Nee.
I am going to make a motion. I'm trying to figure out which specific sections are relevant here. But I think there has been a violation. And the reason I say that is that when someone, when there's a third party involved, all right, if for example, I went to San Francisco General and requested to see the records of Mr. Garza, then they would have to contact Mr. Garza and get him to sign a release form for that to happen. If Mr. Garza wanted his records sent to a third party, chances are that, yes, he would have to sign a release form. This is for his protection and the hospital's protection or the department's protection. But when this is just a two-way transaction, when it's just Mr. Garza asking to see his own records about himself, the task force has held in the past, and I think it's a good interpretation that no signature should be required as long as he can prove his own identity, which he is able to do. Now, another little conundrum here, Mr. Garza has named the Department of Public Health as the respondent because the Department of Public Health is the department with jurisdiction over San Francisco General Hospital. And I have no quarrel with that, but Mr. Garza went to San Francisco General, and that's where he encountered the problem. So I think that even though nobody at San Francisco General is named in this complaint, I think that somebody at San Francisco General needs to be held accountable here, and the person I would guess off the top that would fall to would be Philip Katzenberger, the gentleman whom Mr. Garza identified during his testimony. Accordingly, I move to find Philip Katzenberger of San Francisco General Hospital in violation of Sunshine Ordinance sections 67.21B and C and 67.26.
21B is in boy?
B as in boy. 67.21B as in boy and C and 67.26.
Okay, I'll second that.
We can discuss first, either way. I don't care. Fine, take public comment.
Okay, we can discuss and then do discuss and then public comment.
I believe that would be at your discretion.
Do I have any brief discussion required before I move to public comment?
Well, I think I've already
Okay.
given the reasons for my motion. If anybody else on the task force would like to comment, I'm certainly happy to hear.
30 seconds. Member Pilpel?
I'm certainly open to public comment, but I think my feeling at this point is that this is not really a public records sunshine issue. It's strictly a matter between Mr. Garza and DPH or SF General as relates to his personal medical records, which are subject to DPH's forms and procedures for implementing HIPAA. But I'm open to public comment.
Well, it's my discretion, and do I have any? What? Oh, I'm sorry. Member Oka, did you have something you wanted to add?
Yes.
Thanks.
Mr. Kola, in this particular case, is Mr. Garza's medical record public record?
I think that's for the task force to determine. I mean, I've provided you with legal authority. I'd shoot that back to the task force to interpret that authority and determine whether or not they think these medical records are private or public documents.
But I'm asking you for your opinion.
I'm not here to give opinions. Sorry.
Well, I mean, Bruce, my belief is that, and I'm tempted to at least kind of go along with my fellow member here, because I think it is a public record that is exempted from disclosure. Regularly exempted from disclosure in almost, at least in San Francisco. Exempted from disclosure based upon the exemption, the federal law exemptions, as well as the actual Sunshine Ordinance Task Force. The Sunshine Ordinance has the exemptions for this. So I don't. I mean, I see how there can be improvements in the Department of Public Health to make things clear. And this is no way is saying that, they almost didn't do the right thing here. I think they did the right thing. I think there just could have been an extra maybe little step that could have used improvement. We all need improvement a little bit in life.
Member David?
Yeah, I think what's frustrating me about this case is that, whether I almost feel like whether you think that the records are public records or private records, it seems like that there is a very low bar to jump over in order for the complainant to receive them. It's not like that there's a huge, regulatory mess that he has to go wind his way through to go receive these records. And so I'm a little bit, I feel like that this is a little bit of like making an argument for the sake of making an argument as opposed to an actual desire to get one's records. It seems like if one really wants his records, it's a fairly simple, straightforward process to do that. And so that's my frustration, is that it seems like that there's nothing more for us to do. He knows the steps he needs to take to get the records. It's been made very clear. Doesn't seem like it's like I said, a big hurdle to jump over. So that's kind of my frustration with this.
Member Oka?
I'm perfectly willing and ready to find a violation because even though the person that Member Nee named at San Francisco General is not named in the complaint, the Department of Public Health is responsible and oversees the whole operation of the health system in San Francisco. So I'm ready to find a violation.
Okay, yeah, let's get on with it.
Public comment and a vote.
What? Yeah, do I have any public comment from the gallery? Seeing none?
Hold on.
All right.
I would give you like the 10 seconds to get up there before I would bang the metaphorical gavel. So go on, Mr. Piccarello.
Thank you very much. I'm once again in opposition to the motion. Medical records are not public records. If they're public records, then they're disclosable to everybody, not just the medical recipient. I like the common sense approach by Mr. Martin. Mr. Garza could have simply signed his name and gotten...
David.
I'm sorry, Mr. David.
Oh.
Excuse me.
We'll just call you Martin.
I apologize, Mr. David.
I wasn't used to getting a compliment, so I was a little confused.
It shocked me, too. I'm like, it can't
I'm complimenting Mr. David.
Can't be the man to my right.
Well, I don't see any violation. Your motion is requesting San Francisco General Hospital and the Department of Public Health to violate federal HIPAA regulations by finding a sunshine violation tonight. Clearly, Mr. Garza simply just signed his signature to the document that, we all sign when we want our medical records, whether it's from UCSF, Stanford, or San Francisco General Hospital. We sign our name to a document and we get everything we want. So I'm opposing the motion, and hopefully the majority of you also. Thank you.
Thank you. Do I have any other public comment lingering on the sides? Okay, finally, hearing none, I'm going to move on. Mr. Clerk, can you reread the motion for us?
The motion is to find Phil Katzenberger of the Department of Public Health in violation of Sunshine Section 67.21B and C and Section 67.26. On that motion, Member Nee.
Was it seconded? Who's the second about?
Yes, it was seconded.
Okay, I was just making sure.
On that motion, Member Nee.
Yes.
Nee, aye. Member Pilpel.
No.
Pilpel, no. Member Sims.
Aye.
Sims, aye. Member David.
No.
David, no. Member Highland.
No.
Highland, no. Member Oka.
Aye.
Oka, aye. Vice Chair Fisher.
No.
Fisher, no. The motion fails.
Okay.
There being no further motions, the matter is concluded.
Thank you. Can you call the next item, Mr. Clerk?
Item number 6, file number 14019, complaint filed by William Clark against Dennis Herrera, Jack Song, and Mr. Zintrin, City Attorney's Office, for allegedly violating Sunshine Ordinance Section 67.22C by failing to respond to a request for information
Thank you,
made on
Dr.
January 29, 2014.
Okay, I'll need a motion for jurisdiction.
So moved.
Second.
Victor? Let's make sure
On the
this-
motion of jurisdiction, is there any,
Who was my second on this?
Member Nee was your second.
Thank you.
Let's just, yeah, Victor?
I'll talk to her.
Okay, we got it.
I'll second jurisdiction.
think
We
we
already
did
have a
already.
second. Is there any public comment on jurisdiction?
Mr. Garza, please
Yeah.
leave her alone. Thank you.
I'm sorry, I was just following up on what I was told.
You can do that in your own time outside of this meeting. Thank you.
Let's let Victor handle it, guys.
YouTube guys.
I eagerly await. Let's just see if she wants.
So did you vote for jurisdiction?
We're getting there.
We're almost done, Mr.
Second,
Clark.
please.
She hasn't.
Okay. Can we call that pass without objection?
Was there public comment? No.
There's no public.
Okay.
Was there any public comment on the item of jurisdiction? Hearing none, we're going to move forward. And can I say it's passed without objection? All right.
Thank you, member.
Mistress Clark, you know where we go from here. You have 5 minutes.
Okay, thank you. I just want to bring you up to date on this. This complaint was I filed on the basis of the fact that I received the time billing sheet from the city attorney for FY 12-13 regarding the payment to the city attorney's office for jobs that he did. And as this is the third year that I've asked for this from the city attorneys, and up to this day I have received no information regarding what information was transferred from the city attorney's office to the Art Commission regarding all of the time billing incidents that related to the Sunshine Ordinance or the Public Records Act. This is the first page, which there were 27 instances where the city attorney billed the Art Commission for Brown Acts to the street artists, and then I requested on let me get my dates correct. I requested on I filed a complaint on let's see, on page 356, I filed a complaint. On page 356, they answered the complaint, which I filed on February 19th, and stated that they sent me an email on, I believe it was on February 6th, that I should have received. I did not receive that email at all, and in fact, on that page, this is the document. This document here stated, if you notice, they said that they sent me an email, but they don't provide me with the actual email. They just provide me with a letter that was sent, which said this was sent via email. So, and I didn't receive. I checked my records. They accused me of basically. They said they sent the email to my correct address, but I didn't receive it, and that's why I filed the complaint. And I just want to point out to you that in the Sunshine Ordinance, under Section 6724 III, that the city attorney is required to provide any information or anything. I filed a subsequent request to getting this time billing, where I asked the city attorney if they had any notes, documents, or any records relating to these Brown Acts conferences with the city attorney's office, and that's what I didn't receive, and that's what the complaint is based on. Prior to that, I also sent the information request asking the city attorney if they kept a daily log of incoming and outgoing phone calls from the city attorney's office to city departments regarding advice that they give to city departments. And I received an answer to that, and they said, no, they don't. So what I'm saying is that their only basis to this is the claim that they sent me an email. They didn't send me anything until I filed a complaint, and then they state is they sent this document, which is not a copy of an actual email. It's just a statement saying that they sent me an email. And so what I'm saying is they don't have any logs for telephone calls. They have all these records claiming that these were Brown Act conferences, and I'm requesting some further documentation, as I have in the past, explaining what advice, what information was transferred from the city attorney's office to the Art Commission regarding all of these Brown Act sunshine requests. And to this day, I have not received any information giving me the information of what the city attorney advised the Arts Commission regarding these specific things. And previously, with the Arts Commission, we had lots of hearings, and they refused to give me that information also. So I'm filing this complaint on the basis that they untimely answered, and that they're also refusing to provide me with information that I'm entitled to. And I'm asking, and I'll answer any questions. But that gives you a good synopsis of what this is about.
Okay. Do I have any members of the public that want to introduce facts? Yeah, okay. Mr. Clark, come on up.
Robert Clark. Yeah, I want to continue on this because basically what happened is that the city attorney said, well, we sent this email on that date, February 6th. They also said they did not receive like an error message or anything saying that my brother and I did not get that email. Well, I'm here to testify that we did not get the email. I don't know why they didn't get an error message. I mean, every time we deal with the city attorney or the Art Commission, we have all these mechanical errors. Tape recordings disappear at certain strategic moments. Emails just don't get sent through, and they don't get their error messages. I'm here to testify we did not get that email until that letter was sent to us, which, as is pointed out, is not the actual email that they claim they sent. That could have been written at any date after the complaint, and because there's no way of verifying when it was actually sent according to them. Now, I want to go on further and say, even though that email that they claim that they sent us, well, they only supplied one piece of paper that they said may be a part of what we're requesting. Well, that one piece of paper was just an email between the city attorney. That one piece of paper was just an email between the city attorney and I believe it's Sharon Page Ritchie from the Arts Commission, and all it was dealing with was getting the city attorney to okay the agenda for the executive committee meeting, for an upcoming executive committee meeting. Has nothing to do with any of the pieces of information we were requesting from the Art Commission. And this is this information is important because by sunshine law, any advice the city attorney gives a department in regards to sunshine ordinance requests is public information. And we've been trying for 3 years to get the information from the city attorney and the Art Commission as to what advice the city attorney is giving the Art Commission, because we want to verify whether it's a legitimate cost that the Art Commission, that the street arts program is being forced to pay to the city attorney because we want to be able to, since it's our money, we want to be able to verify if these are legitimate costs that we have to pay. And it's hard for me to understand they can have a piece of paper that they can send at the end of the year with all this list of stuff, but they have no evidence to show how they determine this list. It's impossible for them to do that.
Always makes me wonder if the Clark brothers had been triplets when we've had 9 minutes of this.
My mother was glad we weren't.
I do appreciate the two of you coming well prepared. Mr. Citron, come on up. Oh, were there any other members of the public? Seeing none, hearing none, come on up.
Good evening, Gabriel Zitron of the City Attorney's Office. If you look in your packet, and I don't know the exact pages, you will see the document, the email that I sent to the Clark brothers at their joint email account on February the 6th of this year. The letter which they brought up here is not, in fact, a letter that is separate from that email. It is a letter that was...
Page 349, you're saying?
Yes.
We'll give him a little more time.
Page 13 online.
The letter that they put up here on the projector was one of the attachments to that email sent on February the 6th. Now, I can ask for that to be forwarded to all of you electronically to verify that. It might not be possible or part of the standard procedure. You just have it as your packet. That letter was sent on February the 6th as an attachment to an email that was sent on February the 6th. There was another attachment to that email of February the 6th, which was the email stream that both Mr. Clark were just talking about. They were sent there. For the record, I also included a screenshot of my inbox as having verified that this was sent on February the 6th.
Sent mailbox.
Outbox. Sent mailbox, yes, outbox. Now, why that did not show up in their account, I do not know. I have two possible theories, and they're not set in stone. One is I have certainly accidentally deleted things in the past. Just all it takes is one time. I cannot demonstrate any evidence that this happened, but I can prove that the email was sent. Also, it is my understanding that if Mr. Clark's mailbox was full, perhaps their system would reject the email, and I understand that has happened in the past where other people have tried to send them emails, and that might not generate an error message if they had no space on which to store it. Again, I have no evidence that that's what happened, but I can prove that the email was sent on February the 6th, and that's as far as that goes. I've got the evidence all laid out for you.
But, well, hang on a sec. Do we have any members of the public that want to introduce any facts or evidence? Seeing none, I'm going to go with Member David first and then Member Highland. Go ahead.
So, Mr. Zitron, could you go?
Citron.
Citron?
Sorry,
Citron?
I apologize.
I always think of lemon when I hear citron.
Mr. Citron, so it seems like that you have responded to one of the two issues that were raised by Mr. Clark. You clearly responded to the question of the sending the email, but there was a second part to their complaint about the details of the log, about the information that
they requested all documents that we had. They listed that pertain to certain things. Mm-hmm. We responded by sending them all documents that we had that pertain to those things.
Okay. So I think this is an issue that comes up before us quite regularly about I'm saying that when the city attorney provides guidance with the Brown Act or public records, right, that the city attorney, that is not privileged information, correct? And so I think there's a question of like how much information needs to be put on a log in order to provide the public with that information. And I think this is, at the end of the day, what we're going to be getting at in this particular case. So when you said you provided them, can you point to which page it is in the packet was the information that you provided them?
It's not detailed in any respect.
The chair and page Ritchie.
Gotcha. Okay.
There's no other book. Oh, you got it behind me. Oh.
Let me see yours.
No. We're talking about the email stream. Yes.
Everything else was.
I don't have a page number. This is the email stream.
That's fine.
Between Sharon Ritchie of the Arts Commission and Virginia Dario Elizondo of our office.
Okay, yeah, it's fine. I mean, I think that this is one of the issues that we as a task force wrestles with all the time. How much disclosure is an appropriate amount of disclosure on this particular issue, right?
On which particular, on the issue consultation regarding the Sunshine Ordinance?
Correct. Yeah.
I mean, in this case, this was full disclosure, as minimal though it was. Documents were requested, all documents pertaining to consultation about the Sunshine Ordinance, and all documents that we were in possession of were provided.
No, right, and I think it's more of a question of proper record keeping, and I'm not. I want to be clear. Like I haven't formed an opinion on this particular case. I just think that this is one of the main issues that we as a task force wrestle with. Is that this particular issue, right? That it is not a work product. It is not protected information, and so then and I know that you don't have to produce any document that isn't there already, but at the same time, you also need to keep appropriate records. And this is an issue that personally I find like this is one of those issues that we struggle with. And so I just wanted to I'm curious to hear what other members of the task force have to think about that.
I've got Member Highland.
Mr. Zittrain, in that email, you also BCC'd Francesca Gessner.
I did, yes.
Would she be willing to show us that she received that email? That would clear this up very quickly.
I imagine, although it's possible she's deleted it since then.
Yeah.
I really don't know.
Since she's a city attorney, this is a legal case. Hopefully she wouldn't have deleted it. That's why she might have kept it.
True, but I would certainly hope that the documentation I've provided was sufficient to verify this email's existence without her.
I believe it is, but if that's something that you make a note of and forward to us after this is over, we'd appreciate it. Secondly, getting to the actual meat of the request, those two attachments, PDF attachments, are those in our package?
Yes, they are.
And do they show those 27 incidences that they're referring to, that they're asking about?
No, the request in this case was not for those instances exactly. It was for whatever records exist that document what our advice to the Arts Commission was. And as I said, the only responsive record that we had that would address that question is attached to that email.
Okay, thank you.
Member Neal.
Mr. Clark, please. Okay, you've heard the city attorney's representative, Mr. Zittrain, say that they have sent you all of the requested records that they have. What evidence do you have that they are withholding records, or that they have other records that somehow they just have not provided?
Well, the evidence that I have is common sense. Common sense, allow me a second to answer your question. They create a time billing sheet at the end of the fiscal year to tell the Arts Commission what the costs were, and they have specific itemizations. In order to do that, they have to either have a file with the different city attorneys that they talk to where there's a notation, where they keep records and notes in those files so that they have something that they can add those conferences up to determine how many hours the city spent on public records requests things. And so in order to create the time billing sheet itself, they must have something to refer to. And contrary to what he said, I specifically asked for notes, documents, or records pertaining to the 27 Public Brown Act request. I made it clear in my complaint, and it's in my complaint, that was what I asked them for. So, that's the only evidence I have, is that there's no way to determine that you had 27 public records requests, or the amount of time that it took for each one, and the amount of money that it cost the city and you can't create a time billing worksheet without some form of record to refer to. That seems to me.
Thank you. Do we have Member Sims? You're looking quizzically.
I'm going to try not to ask any questions on this matter.
Well, don't hold back if you've got something.
No, I've got
I'm not here to stifle anyone's creativity.
stifle you.
Member Highland, Member Oka. Mr. Clark, I'm just going to repeat my broken record question. Do you feel like you're missing anything? Did you get everything you asked for?
No, absolutely. I think I'm missing everything. I mean,
Obvious.
I can take any one of those 27 requests and say, well, what advice? It says that there was a conference between the two of them regarding a public Brown Act request, and there's no statement. If they had included in that some sort of a small reference to, oh, this was in regards to complaint number so and so, and we told them to redact this information or to do that, I would have no problem whatsoever. But the fact that they just have such a nondescript thing, there's no information there whatsoever to explain to us what the advice the Art Commission was seeking and what the advice the city attorney gave to them. And even if it's and now they can't even tell you now. If they look at those sheets, they can't tell you what they were about. So I feel like I've gotten nothing.
Okay, thank you. Do you have something before we go to rebuttals?
I have a question for Mr. Clark. So on, I want to say it's page 339 of the packet. It looks like that you were asking, quote, are there any notes, records, or documents associated with those 27 public requests, Brown Act consultations explaining what the city attorney's office advised the Arts Commission in those matters? Right? So you are asking specifically if there are any notes, records, or documents.
Correct.
Right? And so you're not. And I guess I'm asking us, your complaint does not seem to be making a claim that there was that the record keeping, there was not appropriate record keeping. I just want to ask that it seems like that you are specifically asking for the documents if they exist, and that maybe one could infer from that complaint that you're also saying that documents should exist, whether they do or they don't. They should. Is that?
Well, that's basically what my question was. But like you said, the inference from the implication of the fact that the implication is that they, on these Brown Act requests, the implication is that they talked about something, that there was some advice given, and all I can infer is that in order to create the billing document, they have to have some sort of way to have reference to each and every one of those individual conferences.
Thank you.
Mr. Zittrain, question for you, please.
No, that's okay. I had nodded. I'd given you the nod.
All right. What records do you keep of these kind of discussions and consultations?
That's going to depend on, there are a number of attorneys who advise individual city departments, and they may conduct a number of those in different ways. Some of them may be conducted over email. Some of them may be conducted over the phone. It seems like it would be a lot more efficient if they were. But I can't say that there's one method of record keeping that deputy city attorneys use in consulting with individual departments.
When I was a paralegal, I had to track every 6 minutes of work to different projects. So I know record keeping is pretty strong within law firms and legal institutions. So when you're saying there is nothing responsive except for one document, is it because those documents don't exist, or are you perhaps invoking some other sort of exemption to not produce?
No, if we feel we have documents that exist that are responsive, but that are exempt for some reason, we will inform someone that there are additional documents that are exempt, and then we'll give them the reason that we feel those documents are exempt. That's not what happened here.
Okay. So this looks like a one-sided transaction. There was 27 public requests from this department, but it doesn't seem to appear on your end. I find that troubling, or at least interesting.
Well, my response to that is that most likely there were a lot of phone calls, and I say most likely because I don't know. I get a lot of this information from elsewhere, as you know. But it's not that all the data was going one way and not going the other way, or that all the records were going one way and not going the other way. It's just that what we have at the end, the document that he has from, I believe, a prior public records request, which lists those 27 consultations, that each of them lists an instance not of data going one way, as you suggest, but of a consultation between the Arts Commission and the City Attorney's Office.
So it's your understanding that most of these, if not all of them, but one, are phone calls?
I don't know, and I don't want to speculate because it was not me who had those in any respect. So,
Madam Chair?
Yes, Member Nee.
If Member Highland is...
Yes, I'm definitely.
You're done,
Okay.
yeah.
Even if the consultation takes place by phone or in person, verbally, doesn't that generate some kind of a billing from the city attorney's office to the art commission or whoever is seeking the advice? Doesn't that generate some kind of a billing or statement or anything?
My expectation would be that there is a billing of time to matter numbers, individual matter numbers, and I don't know off the top of my head whether this kind of consultation would be billed as a matter number that is given the name of general work for a particular client that's being a city department, or if there is something more specific to Brown Act or Sunshine requests. It certainly does seem to me to be time that attorneys would bill in some respect. So, I mean, I see where you're going with this, and as far as where billing records are kept, and I'm thinking, okay, well, it's also possible that the way that billing is kept, for example, in consultation with a city, or call it the Arts Commission, consultation with the Arts Commission is a billing nomenclature that would apply to a number of different kinds of consultations and not necessarily those that pertain to the Brown Act or to the Sunshine Task Force. And again, that's just a guess.
So,
Go ahead, Member Copeland.
sorry to ask a question. Could the Clark brothers bring up that one pager with the time entry report that shows 000496?
That shows what now?
I'm looking for the code 496. It's the city attorney time with the Arts Commission. It's not in our packet material, but you had that up on the overhead earlier, and it was the subject of a proper complaint. That might
Give me a second.
Yeah, okay. And that might help, Mr. Zittrain.
I have a different copy here that's a little, not as quite as...
No, not that.
Which one?
The chart with the hours, the hours and the money.
Do you want the first page?
Sure.
Because I have another page here which...
That's okay. That page is good. And if Mr. Zittrain can take a quick look at that.
I just want to point out to you that on this page, there's two categories where there's a phone call made, and it's recorded down there as a phone call.
Understood. So, to Mr. Zittrain, this is a copy of your office's
Yes, this
billing
should be
records.
what Member Nee was referring to, or at the very least, notations that are made by attorneys that wind up in this system.
Victor, can we shrink that?
I believe that each...
That works.
Yeah, each attorney is listed, and number of hours are listed, and pay rate is listed. I mean, it's a billing record. And I believe this was produced pursuant to another request that they had made by the Sunshine Ordinance.
Okay.
So there's a record.
So
Don't go too
back
far
to the
yet.
question that Member David brought up, the detailed record keeping. Obviously, we see that there's hours and hours of consultation here.
Mm-hmm.
What was the substance of that consultation is the request. And kind of back at square one.
Having said that, we are at the point where the respondent, hearing no other comments from my task force gentlemen members, we're going to hear from the respondent. He's going to have 3 minutes for rebuttal and conclusion, and then we will hear from one of the complainants.
I
You'll
will
get
yield
3
my
minutes.
time in the interests of brevity. Thank you.
Thank you. I just want to point out to you that just a few minutes ago, he misrepresented to you what my complaint was based on, and he said that it wasn't based on a specific points that I made, which I feel is pretty deceitful for him to even say something like that when it's covered in the complaint. And like I said, I want to point out to you, like I said, I asked them whether they keep phone logs. They said, no, they don't keep phone logs. Yet here, under right here, if you notice, that's a phone call that we were charged for. It wasn't public records, but it's a phone call, and it indicates that if it's a phone call, they can put down there that it's a phone call, and that if it had to do with public records, then they should keep that information. They should provide that information to us. And what I'm saying is that they have all this information, which they gather at some point in time to write a time billing thing, yet we have no reference, we have no documents, records, or anything that say, well, this is what we chose, this was what we met about, this is what we talked about. And in regards to public records, Brown Acts, this is all public information that if I want it, I can get it. Yet now they tell me that, well, we don't have any records, yet they have the records to be able to produce a time billing sheet that contains all this information. So either as these things are happening throughout the year, somebody is writing somewhere, the attorney that gave the advice to the Arts Commission is writing down somewhere that I called them or I emailed them, I did something to them, and I spent an hour and a half talking to them about this subject. Otherwise, how do they even know that these things occur? And that's what we're saying, is we want to make sure that these things aren't just pulled out of the air, and that the Street Arts program gets charged all this money for a public records request, yet we can't find out what was discussed, what the advice was, and even the other categories. Okay, they may be privileged, but in regards to public records requests, there has to be a record with the attorneys that had these conferences. There has to be some note, some document, something in their possession, and they're not allowed to destroy them. They're not allowed to just destroy those records. So there has to be something there. So I'm just saying that I think the city attorney is being deceitful and deceptive to claim that there's no records to support what this information shows.
Okay, thank you. Who are you asking? Mr. Clark. Yeah, Mr. Clark.
Mr. Clark, could I just ask a clarifying question? I just want to make sure I understand. The document that you just had up there, that was not in response to this particular complaint. Is that correct?
No, the complaint was, my complaint was regarding the items in this document.
Yeah, he wants to know
That was
that.
subject to a previous request.
Yeah.
This was a previous request.
Thank you.
So like what's going on with this stuff? Okay. Having clarified that, gentlemen, I'll ask again, do I take a few minutes? Got nothing?
I mean, here we are again about documents that do or don't exist. Unless other members see it differently.
Member Nee?
Well, the thought that pops into my head here is if these documents don't exist, they should, and that would maybe indicate a violation of 6729.7, The mayor and all department heads shall maintain and preserve in a professional and businesslike manner all documents and correspondence, including but not limited to letters, emails, drafts, memorandum, invoices, reports, and proposals, and shall disclose all such records in accordance with his ordinance. If those documents don't exist, they should. You can't ask. You cannot ask a document to be created out of thin air. I mean, if the document doesn't exist, then okay, it doesn't exist. But at the same time, there's some long-term policies and practices that I think come into play here, and I am quite concerned that the information that the clerks would like, that would basically kind of underlie the record they have shown us a few minutes ago, isn't there, and it should be. That's just my off the top thought, and I would welcome comments from colleagues.
I had a question for Mr. Zitron again, if I may. Clarify your position again with the City Attorney's Office.
I'm sorry, on what's
your title?
More specific. Oh, my position? Mm-hmm. My official title is Deputy Director of Communications.
Okay. Is there someone in?
Is Matt your boss, or
He
you
is.
report to? Okay.
Is there someone perhaps in billing that would be more qualified to answer these questions, or record keeping, or another ancillary department?
Yes and no. I mean, if you could get somebody up here who would say, this is how we aggregated this, I took data from out of the system based on how everybody builds something. I don't know whether those records are searchable by the particular term phone call or such. I don't really think it would yield you any real additional information that would be helpful to you. You'd simply say, it would yield you the document that you just saw. It would yield you the billing record. And somebody might be better suited than me to say this is how the billing record was tabulated, but at the end I'm not really sure how that would answer the inquiry in this particular case.
Okay, perhaps the attorney listed on that document that they showed us might be able to answer these questions.
Well, there are a number of attorneys listed on that document.
It looks like just one from what I saw. Maybe I misread it, but
well, it's
mostly one.
Mostly one, because city departments typically have one deputy city attorney who advises them.
So,
now, if she were here, she might be able to say, yes, I had this phone call on such and such a date, but given the way that memory works and how far back these things were, my guess is that she would simply be reading them off the document.
But she could probably tell us that, we've been dealing with 3 main issues in the last 3 months. The majority of the calls were to this. Here was an actual document that was something different. We would get some background, and that might answer their question.
With regards to the content of the discussions?
Yeah. And would there be any privilege waived there, or any privilege invoked?
I'm hesitant to answer that definitively. I would certainly raise the question.
Okay. Thank you. If nothing else, if we choose not to make a motion or, not move forward with this, perhaps advise the Clark brothers to specifically make an IDR to that particular person. Would that be sound advice? I would welcome any discussion on that.
Can you repeat that? I'm sorry, I missed.
Sure. So we're wondering if there was an attorney named in that document, more than not, and I think that's the attorney assigned from the city department, city attorney's office, to the Arts Commission. It'd be nice to have that person in front of us, because that person might remember the nature of the phone calls and the subject and any documents thereof. So perhaps moving forward, obviously this is a long process that the Clark brothers are going through to get this first spreadsheet and now get the information. Perhaps that person directly should be named in a complaint or an information request going forward. That was my thought.
But for that person, so if this person comes up here,
I think he is representing that person, right?
Yeah, I think you're representing that person, first
Yeah.
thing. But the second thing, if the person comes up here, are they just going to give us what's written on that sheet?
It's entirely possible. I think it's a bigger issue is actually whether if the Clark brothers were to submit another IDR, it would be another IDR for written documents that are in existence. So that actually wouldn't really solve that issue. You see what I'm saying?
Yes, because these are, you're saying, I mean, we've kind of gone through this before, because these are the written documents that are in existence.
Right. I mean, if you're asking for oral testimony on the content of, you're not asking for oral testimony on the content of those consultations. Okay.
No,
At least Mr. David is shaking his head. You might, I don't know, you might have a different answer.
But surely this attorney would have kept notes about oral consultation. Who wouldn't? I mean, and there should be those notes, I would think. And they are asking indirectly or indirectly for those notes.
Yes, because these would be an exception to the attorney-client privileges. Yeah.
You leaving?
And if, when this was, there was another step.
It's cold.
I just don't want to lose our next respondent here. Gone.
Okay. And yes, if such notes were found when we performed a search for the documents when we received that request, if such notes were found and determined not to be subject to any exemption, they'd have been provided.
Or if there was an exemption, you would have asserted it.
Or, yeah, right. Or we would have asserted it and why we felt it was legally justified.
So you're stating that that particular attorney has no notes that you're aware of?
That we were able to locate her, that she was able to produce upon receiving that. Because,
Okay, thanks. Do we have a motion? Do we have a motion on the floor?
Member Nee, did you make a motion or were you just pondering one?
No. I did not make a motion.
Okay, well then I would like to make a motion.
Make away.
I would like to make a motion to find a violation under 6729.7 of the Sunshine Ordinance for basically not keeping appropriate records and professional records. I feel like that this is an issue that comes up before us all the time, and it would be really helpful for this to go to a subcommittee where we very clearly state what the expectations are from the city attorney under this very limited on information around the Brown Act and around public records request. That there has to be more information than what is just kept in those billing sheets. That's kind of my take. So, was that clear what my motion is?
I'll second it for discussion.
We've got a second,
Further discussion?
and we're going to have a little bit of further discussion, and then we'll have to move it to public. Then we will move it to public comment. Go ahead, for Pilpel. Who else?
All right, so I've been pretty quiet on this. I think I am not with the motion at this time. Couple of points. This is actually one of the sections of the ordinance that's at issue in the Alan Grossman versus John St. Croix case, and we have not heard about that yet. We will at a future meeting. It's entirely possible that the two related sections of the ordinance may be struck down, which would, I think the technical term is suck. So, it's somewhat in play. The other issue for me is I think the city attorney's office is very well aware of the ordinance and all of its implications, including these particular provisions. They are aware that there are a number of public records requests for issues at the Arts Commission, including the Street Artist Program. It wouldn't surprise me at all if, through that long list of the 27 consultations, that except for the one email chain that was disclosed, that all of the conversations back and forth were oral, and that if there were any notes from that they weren't deemed records under the admin code and were not kept in the ordinary course of business. That would not surprise me at all. That would seem to me to be a reasonable interpretation from the city attorney's office as to how to both comply with the requirement to advise departments and yet not create records that would be subject to disclosure. They're very well aware that if they create a record or retain a record in connection with this advice, that it's subject to disclosure. And so as to avoid doing so, they would not do so. And they would simply say, please describe to me, what you just got. Is it another request from the Clark brothers or Ms. Datesh or anybody else? How do you propose to respond? What do you think? Da-da-da-da-da. And they would just discuss it and not result in any record. So it doesn't surprise me that the only record was this email chain back and forth about an executive committee agenda. That doesn't surprise me. That doesn't mean that I agree with that course of action, but on the instant complaint before us, I don't see a violation. It doesn't appear to me that they're not retaining the records that they're required to retain in a business-like fashion, which is why I'm having trouble reaching 29-7. Thanks.
Madam Chair?
Yeah, Member Nee?
I want to disagree with Member Pilpel on the applicability here of the Grossman case. That the Court of Appeal has not yet ruled on it. Right now, there is the last decision that came down was from the Superior Court, which upheld Mr. Grossman's position. Therefore, until such time as it is struck down, the relevant section, 67.21I, is the law.
That was actually stayed by the Court of Appeal.
I'm sorry?
There was actually a stay issued by the Court of Appeal.
It was what?
Yes, there was a stay issued by the Court of Appeal, but that's
Court of Appeal.
But that's
in the ordinary course of judicial. I mean,
Well,
But
no,
that-
it was
but
a
that
discretionary
doesn't-
stay.
that
I think
doesn't- that
it
doesn't
was either
strike
a
down
discretionary
that-
stay or supersedious that was granted.
That didn't strike down the law.
No, but
It didn't invalidate the law. The law is still valid, still in effect.
Gentlemen, don't make me pull this building over and separate the two of you. I'll do it. My mother did it in a station wagon. Can we have the motion? And do we have any further discussion that is related to what we are talking about right now?
And then public comment.
Where was it? Public comment
On the motion.
do I have any public comment? Let's reread the motion.
The motion.
Then I'm going to take public comment on the motion.
What is the motion?
We're going to reread it right now.
Thank you.
The motion is defined violation of Sunshine Ordinance Section 67.29.7 for not keeping appropriate records
In a business-like manner.
in a business-like manner.
Thank you, Mr. Clerk. I strongly support the motion by Member David. Little history here regarding the city attorney and their billing practices. As Member Nee would recall, 3 years ago, the city was asserting work product privilege and never had to disclose how they would bill other city agencies and city departments. To their credit, they seen the light that's not legally sound. So I applaud Mr. Clark for bringing this issue. It's been a long-standing problem with the city attorney to get documentation as to how they are billing city agencies and city departments. So at best, the city attorney destroyed the documents. Nobody asked them if the documents have been destroyed. You just asked him if the documents existed, and he said no. Perhaps you should have asked him if the documents were destroyed, if he knew. And he doesn't seem to really know the billing practices of the city attorney. So perhaps you could find a violation of the Sunshine Ordinance for not presenting somebody here that knew what the hell they were talking about. And at worst, the city attorney is violating probably the controller's office practices and procedures on how to bill city agencies and departments. It can be fraudulent billing if he's just assigning a number without any rational basis. You know, to say, we're going to bill the Arts Commission $500 for last week's work, but then has no documentation as to what exactly the work was. Certainly, the controller's office has policies and procedures that mandate that he do much better. So I urge you to find a violation and then perhaps compel the city attorney to bring somebody to you to explain to you how they bill city agencies and departments that we're all responsible for. Thank you.
Probably roasting on a spit.
I want to call your attention to a Arts Commission complaint, maybe last month or the month before. Possibly it was the Clark brothers who brought it. We're all familiar with the handwritten accounting of sunshine complaints of Howard Lazar, but at that particular full task force hearing, Aideen Vera, the city attorney assigned to the Arts Commission, was asked to appear before you. She didn't appear. And I think those kind of questions would have been asked at that time. How do you bill? What is your procedure? She didn't appear, and Howard Lazar just said, well, I kind of mentioned it, and it was just dismissed. I think this issue is going to come up over and over again between the logs of the street artist program, handwritten, unverifiable, some weird spreadsheet where they continue to lose IDRs, and this issue here. And unless something is brought together and consolidated, I think it's going to come up over and over again.
Thank you. Any further public comment? Pause. Hearing none. Mr. Clerk, can we, let's get rolling on the vote.
On the motion to find the city attorneys in violation of Sunshine Ordinance Section 67.29.7 for not keeping appropriate records in a businesslike manner. On that motion, Member Nee.
Aye.
Nee, aye. Member Pilpil.
No.
Pilpil, no. Member Sims.
Aye.
Sims, aye. Member David.
Aye.
Member David, aye. Member Highland.
Aye.
Highland, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Fisher.
Aye.
Fisher, aye. The motion passes.
So, actually, I was going to go compliance amendment. I've given this a lot of thought over the last hour and a half, and better part of today. And, I don't see the need to drag the city attorney to this meeting every single month. But, I got to tell you, Miss, I'm a little curious, Mr. Zitron, and I'd like to see you again, or no, not now. I mean, and hear a little bit more about this billing procedures and how you guys do business, and maybe in a smaller subcommittee, we'll see some reasons and we'll understand. I don't really think this violation is punitive. We're not a punitive body, but Member D, I'm going to ask your opinion on this. I'm leaning towards sending this to compliance and amendment, since that's my old theory of whoever misses the meeting gets the action item. Sorry, Allison. With your experience, is this more compliance or is this more EOTC?
Well,
I'm leaning towards compliance.
Off the top, I would say EOTC, but if we're going to send it to compliance and amendments, I think the order of determination should instruct specific remedy within a certain time frame, what would we want the city attorney's office to do within the 5 days going forward from the time it received the order of determination? What would we want the instruction to say?
Yeah.
I would lean toward education, outreach, and training, because I think it would be a bit more flexible in terms of how the city attorney's office and the task force would interact going forward and reach some kind of a solution.
Okay, I was just balancing that out, and Member Washburn, you dodged this one by not being here.
Well, if some of my colleagues might have another view on this.
No, I've gotten enough input from my colleagues to my immediate left and right. I'm going to send this to whatever the next meeting is for EOTC.
Do you have any specific instructions to EOTC?
Or better yet, who from the city attorney's office appears at EOTC? That's something I'm interested in.
Could we get one of the, I'm asking
How about
Mr.
the attorney?
Can we get the attorney, Mr.
That's
Zitron,
responsible
to
for
come by?
Arts Commission.
I don't know his or her name. You think we could get them to swing
Well,
by?
Aideen Vera is the attorney who represents the arts or consults with the Arts Commission, but I think you may actually be asking for somebody in the billing department rather than the relevant deputy city attorney.
Could we have both of them? I mean, it's a short meeting.
I don't know. Is that
Okay,
decision? I don't
sure.
even know who would make that decision, but it probably wouldn't be me. So,
Yeah.
I mean, it's also possible that I could simply learn from them
Who do you want?
everything it is that I need to know for that.
I'm going to defer to Member Pilpel. He's the chair of that committee. Who do you want?
If we're going to have a serious discussion at EOT, because we've had the Clark brothers and Ms. Detach, lots of people have been concerned about the Arts Commission. It really would be good if we could get Ms. Vera. I think at this point we're somewhat less concerned with the billing practices in the abstract and more concerned with Ms. Vera's billing practices and how the Arts Commission in particular is billed and what record keeping occurs with respect to requests for advice under the Acts. So, and if not her, then Ms. Gessner or someone else from the government team that actually has had to advise the Arts Commission on these matters. I think that would make the most sense, and we'll see where we go from there.
Okay, so we're not really looking at general billing practices, we're looking at this case.
Yeah.
I think so.
I think we're on this case.
Yeah, and she might be
If
able
we learn
to.
anything greater about billing practices, great, but I think let's try to keep this focused on the Arts Commission. There's enough there.
I'm good with that. Okay.
We'll
You
schedule
got
that
enough
for June.
information, Mr. Clerk?
Yes, I
Clerk, not Clark, sorry. Clerk, Mr. Clerk? Mr. Victor? Okay.
He's one of the Clerk brothers.
Oh, you're the third Clerk brother.
Mr. Martin.
Never mind.
Let's go, Groucho.
All right.
Thank you.
Thank you, everyone. Mr. Clerk Victor Young, can you call the next item?
Item number 7, file number 14020, complaint filed by Gary Howe against the Office of the Treasurer and Tax Collector's Office. Apologize for that. The Controller's Office, the City Attorney's Office, for allegedly violating Sunshine Ordinance Section 67.21 by failing to adequately respond to a request for public records dated February 1st, 2013, Treasurer Tax Collector, December 10th, 2013, Controller's Office, and January 21st, 2014, City Attorney's Office.
Madam Chair, I move to find jurisdiction.
Second.
All right. Do I have any public comment on jurisdiction? 3, 2, 1, hearing none.
Question?
A question on jurisdiction?
So I believe we have someone from the Treasurer Tax Collector's Office. Do we also have a representative from the Controller? And is Mr. Zittrain here from City Attorney? Is there someone from the Controller's Office as well? Okay, but you're sort of covering for your office.
I'm here for the Treasurer and Tax Collector's Office.
Got it. And we've got someone from the City Attorney. All right, well, we'll go forward and see where we go.
Where are we? We have a motion, we have a second. Yeah, so we've got a motion, we've got a second. I'm going to go, we have no public comment.
Jurisdiction.
On jurisdiction, we've passed, no objection. Okay, so we're jurisdicted. After 4.5 hours, I reserve the right to make up my own words. I'm not from the professional journalists. So we have jurisdiction. So now we're going to get right to the hearing. We're going to hear the complainant first for 5 minutes, and then we'll hear the respondent. So, complainant in this case. Hi, welcome.
Good evening. My name is.
I'll need you to, yeah, thank you.
My name is Jamie Liu. I represent the named complainant.
Directly into the mic.
Yeah, it's kind of right into the tip here.
That's better.
Okay.
Yeah.
Sorry. Yeah. My name is Jamie Liu. I represent the named complainant, Gary Howe, as I was the one who actually filed the complaint, and I authored all the written communications showing both our names. He was included because he's the legal owner of the concerned real property, but he was spared the case details. In terms of the issue, it's actually summarized in the opening paragraph of the February 18, 2014 email to the task force. We have been requesting the public records since the February last year from the tax collector's office, the controller's office, and the city attorney's office. We have gone full circle. The tax collector's office and the controller's office defer to the city attorney's office. That's why they were involved, who forward us back to the tax collector's office. We have not been provided the document we requested, neither have we been told that it will not be provided or why, as required by the California Public Records Act and the Sunshine Ordinance. They simply just ignored our request for the document. So to today, we still do not have the document we requested, and we have no justification from them, any of the three offices, why that is.
And the document you were referring to is?
It's a payment transmittal from the ACH operator to the tax collector's bank, Wells Fargo, in this case, we believe, showing the transmission date or the payment arrival date.
Okay. Okay.
And to clarify, they have volunteered certain documents that were not what we requested. So they were mostly internal records generated by either their departments or Wells Fargo. We have no way of knowing the source. But what we are really interested in is the third-party source document directly from the payment processor, ACH operator in this case, I think, transmitting the payment to the tax collector's bank.
Okay. No, we have 5 minutes, and then we get public comment, and then the other side, and then the respondent gets 5 minutes. So is there any members of the public who want to offer facts and evidence? Okay, hearing none. Can I hear from the respondent? And I have multiple.
There's 3 respondents.
Do I just pick one, or do they each? Why don't we hear from the one that stepped right up to the podium first? Ms. Prophet, I believe it is, from the tax.
Yes, my name is Stephanie Prophet. I work for the Office of the Treasurer and Tax Collector. I'd like to begin by just giving you a little bit of background. If you own real property in California, you probably are aware that your property taxes are due by December 10th of each year. In this case, the homeowner at this property logged on seemingly to their Wells Fargo account and attempted to do a bill pay transaction to pay their property taxes. Our records, the Treasurer and Tax Collector's Office's records indicate that the payment was received on December 11th, which is 1 day late, and therefore a late penalty of $50-something was assessed to this property. And I think that that's the reason why the complainant is seeking this information from us. We have turned over all the records we have regarding the date that we received this electronic payment. And I would also like to point out that according to our records, Gary Howe is not the owner of this real property. Somebody else is, and because of that, we did redact a few items of information on one of the statements that contained financial transaction numbers. The Controller's Office was included in a lot of emails. It's my opinion that the Controller's Office really wouldn't have this kind of information, and neither would the City Attorney's Office. This is really a transaction that is managed by the Treasurer and Tax Collector.
Isn't that you?
Yes.
Oh, okay.
Which is why I'm here.
Good to have you here.
That's all I have to say. Thank you.
We'll have some questions. Could we just hear from Mr. Zittrain?
I would just like to state for the record that one of my best friends is a deputy at the Treasurer's Office, and I feel like I should recuse myself from this case. And so I just wanted to.
No.
I know.
Is it Ms. Prophet?
No, it's one of her colleagues, and so.
Do you feel like you can be impartial?
Really? I mean, this is tax. Come on, you can't be impartial about tax.
I mean, if you feel like you have trouble being impartial, then I think that would be wise to do. But otherwise, I don't think it's
be justified.
Either justified or a conflict or the appearance of impropriety.
Okay.
Or the appearance of a conflict.
And if you're trying to get away early, nice try.
No, I'm not trying to get away. I'm there sitting through the whole.
As long as you can.
The reason I'm sort of giving you this quizzical look is because David Augustine, who is the deputy of this, is my co-chair of a club, and I feel like I can be pretty impartial on this.
Okay.
So.
I just, as long as you feel you can be impartial. It's fine. I feel like I just want, I want to.
I should probably put that out there.
Disclose?
Why don't we just go down around the horn here and disclose? I mean,
Disclosures are supposed to be handled as the first item before we get into this. Do you want to disclose who the individual is
No,
that's
I
at issue?
don't, no, because the person's not here. I will sit and listen to the case. I just wanted to, I felt that I feel like that it could be difficult for me to be impartial in this case.
Member David, in this case, could you be impartial?
I think that I can be. I just think that it's going to be a little bit difficult for me. I just wanted to.
I think the balance would be in the interests of the complainant since we have so few people here.
Okay, I will sit in.
for the record, since you've brought it up, I didn't even think about this, but my co-chair of a very small committee for a club I'm on happens to be Jose Cisneros' deputy, but in no way other. I see the guy once a month, and I mean, he's a great guy, but I don't see how it would. I don't really consider him a quote close friend. He's a colleague of mine, but I don't see how that would impair my decision at all. And didn't even think about it until you just brought that up.
Madam Chair, Member David has said he might find it difficult to be impartial.
That's concerning me a little bit. Yeah.
Because of that, I appreciate his coming forth with this disclosure, and I will move to recuse Member David from this item.
Yeah, sorry guys.
I agree.
If personally, I have
hold on,
fewer
don't leave yet.
objectivity. Oh no, you're going to sit in that corner and you're going to think about this.
We have to dispose of the
need
matter
to
first.
vote on this?
You have to vote.
We have to vote on it.
Right.
Yeah. We do.
The motion is to.
Go ahead, let Mr. Clerk take
The
over.
motion is to recuse Member David from this item file number 14020. The motion was made by Member Nee, seconded by Member Oka. On that motion.
Wait, discussion?
It's procedural, right? It only has to be, it doesn't have to be 6, it just has to be a majority, right?
I don't think there's a discussion on.
Yeah, I don't think we need
motion
discussion.
to recuse.
I would like to discuss, because I believe under the relevant Campaign and Governmental Conduct Code section, the member who makes a disclosure needs to disclose the individual with whom they have the relationship, not to just disclose in the abstract that there is a relationship. So that's why I'm asking on the record.
Mr. Cola, can you shed any light on this? Because I don't even want to touch this one.
That would be new to me, too. I don't know. What code section did you
So
say?
let's err on the side of caution on this one and just go with the motion. And
I'm not opposing the motion. I'm just asking for disclosure on the record of the individual. I believe you named the individual, and I'm just
I did.
asking.
That was my
Member David,
prerogative,
if you can
though.
just name the individual with whom you
Gotcha.
have the relationship. That's all.
Okay, Member Oka, you've got something.
Yes. I've been involved in many of these type situations in federal and city, and in my view, it is not necessary to disclose who the conflict is with. So in that case, since Member David is asking to be recused, I think we ought to honor that.
Yeah, I mean, I can't, as much as I would love to, I can't get inside your head. Although, no, I wouldn't want to go there. So, like, where I can sit here and say, I got no problem with this, it's a personal thing for you. So, we have a motion on the floor, correct? Yes. And do we do a vote, or do we just
Yes.
pass it? Let's
Yes.
do the roll call vote.
On the motion to recuse Member David, Member Nee.
Aye.
Nee, aye. Member Pilpel.
Aye.
Pilpel, aye. Member Sims.
No.
Sims, no.
Ooh, nasty.
Member David.
On my own?
Yes.
Yeah.
Aye.
Aye. Member Highland.
Nope.
Highland, no. Member Oka.
Aye.
Oka, aye. Vice Chair Fisher.
Oh, I could swing this. I'm going to say aye. I'm going to err on the side of caution here.
Fisher, aye.
That's aye, so it's
That is a vote
procedural,
of 5-2.
So it's procedural, so it just has to be a majority?
I am unsure of that.
I am
I
too.
think we need advice from the city attorney on that.
We have one of
But
these.
well,
We have
not
one
so
of these.
fast, Member David. No, it's good.
We
No,
haven't-
we're not done yet.
Yeah.
I thought that was procedural, so it's.
You get to vote.
We get, I believe it's
Motion did not pass.
procedural. I thought it was
Has to have
procedural.
6 votes.
I thought with procedural, it only had to have.
Procedural requires a majority of those present, and I believe that applies here.
Yeah, I thought it was procedural. Yeah.
We did this last month,
Yeah, we had this once before.
recently.
Go sit in the corner.
3.214
Okay.
of the CNGC code.
I don't know what we're arguing about. He wants to be recused.
The problem is.
Well, I think he's got the vote, so.
Vote of
Yeah.
pass or fail, that's what we're arguing about.
And I don't think it's for any of us to get in someone's head what they feel about something. If it were, then we'd all have really
Have
good
we,
or bad
have we had
relationships.
facts and evidence in favor of the complainant?
Where did we leave off? We heard from both sides. We've
need to
had,
hear from Mr. Zintrin.
right, we're going to bring Mr. Zitrin up
Can we-
as a, I believe we've heard from Ms. Prophet. Bring up Mr. Zitrin as he is a respondent, so he gets, does he get 3 minutes or does he get half? Or how does this?
3 minutes.
He's another
5 minutes.
respondent, so he
He'll be
gets,
quick.
I mean, sorry, I meant,
5 minutes.
just talk.
Thank you. I do feel really bad about where this case went and how it was handled, particularly by me. It turns out that no, it is not our office's responsibility, as Ms. Prophet is saying. This is properly with the treasurer and tax collector. I spent a while just trying to figure that out and becoming lost in this dizzy array of city agencies that were all referring them to one another. And did they get the runaround from city government? Yes. And should I have done a better job of communicating that we weren't the proper office? Absolutely. And I really wish that I had done that better. And the fact is that 10 times a day I get requests from people that are basically amount to legal advice that's more properly given by private counsel. And I wish to heck that I could handle each and every one of those and give it the attention it deserves. I do my best. Sometimes I do pretty well. Sometimes I do pretty poorly. I would classify this as being a time that I did poorly. But nonetheless, I got completely lost myself trying to figure out what is it that our office is supposed to do. The answer is this properly lies with the treasurer and tax collector's office, and trying to get consultations with a number of people in the city attorney's office who either weren't there or who weren't sure, and this became a network of communications that was a complete breakdown, but we eventually wound up with the right thing, and now Ms. Prophet is here and hopefully can address what the complainant's needs are a little bit better than I can. I mean, if I had it in my power, what I would do is I would say, okay, you know what, let's sit down all three of these departments, right now and figure out exactly what's going on and how we handle it. That is way beyond my power. I have discovered to organize such an interdepartmental meeting as that one. But nonetheless, I don't feel good about how I handled this, but as I said, I do the best I can with people. I try to give them advice. I can't always do it when it's not technically the role of our office. It doesn't mean that I think I did a good enough job communicating with you, so I apologize for that.
All right, where are we? Are
Facts
there
and
any
evidence.
members of the public that want to offer facts and evidence? I'm going to guess no. So now we're going to allow the task force members to
Madam Chair?
discuss. Yes, Member Nee.
Ms. Prophet, please. What the complainant said they wanted, and that your office has not provided, is the actual ACH, which I guess stands for Automated Clearinghouse, report of the transaction. Does your office receive that report? Does it have access to that report?
I worked with the banking department of my office to get records of all of the records that we have that show when we received a payment, and we turned over all of those records. Whether or not it's always called an ACH, that's a little beyond my knowledge of banking. But the records that we've provided, I think, pretty clearly show the dates that the payment was received.
Well, I don't think that there's any dispute dispute on that. I think that the dispute is where the records came from and where a specific record came from, and whether that record was provided. Do you have access to that when this transaction is generated? Who produces, where do the records reside? When a transaction takes place, it generates records where and where?
It's my understanding that when an individual electronically transfers money to the city, it hits the bank's bank, the city's bank, which is Wells Fargo in this case. And we have a record from Wells Fargo indicating that the payment was received on the 11th. I also believe that in the email communications that were provided to you as part of the complaint, we have statements in the emails made by the complainant or by Jamie Lou indicating that they made the payment on the 10th, that the tax bill clearly states that payments made through bill payment will only be counted as received once the city's bank actually receives them. And they acknowledge that in their emails to us. So I think at this point everyone is in agreement that the payment was received on the 11th. And in any event, we have provided all of the records that we have regarding receipt of the payment.
Thank you.
Hold up, I had member.
I think my knowledge of the actual intricacies of online banking might be a little limited.
Been there.
But I think that anyone here who does online banking realizes that just because you click pay doesn't mean it gets received that same day.
So I'm going to go with member Pilpel and then member Highland.
I think I have three specific questions. You said that your records indicate that Mr. Howe is not the property owner.
That is correct.
Can you tell us who the current property owner of record is for the subject property?
I can. The current property owner of record is Martin and Henrietta M. Howe Living Trust.
Okay. And I guess in relation to that, how do you deal with a trust in terms of who the owner is my understanding is that more property now is held in trust or by a TIC or all kinds of these other funky devices. So how do you
So then the beneficiary of the trust would be the individual that we would deal with.
And how do you determine that?
The trust document generally states who's the beneficiary of the trust.
Okay. All right. I just thought that was interesting. The report that we have on page 380 of our packet, labeled home banking transactions, part of the, I think, TDA 820 report. Are you familiar with that?
No.
Okay, but you're getting...
I don't have those page numbers that you have, but I probably have the document you're talking about.
Victor, can someone share this?
Yes, I have it.
Yeah, you have it. Okay. All right. So 380 of the packet.
All right.
Is this the report that your office generates as to payments received?
Yes, this is the document that we provided to them, and I can just flash this. You can see it had a lot more information, but we redacted all of the other information.
Okay.
Since it dealt with other taxpayers, and it included confidential information about this particular transaction. But that is a home banking transaction spreadsheet.
Got it.
Summary of all the payments that were received on December 11th, 2012.
Got it. For whatever it's worth, the other transactions that you redacted in providing to this?
Yes.
Ms. Prophet? Were those individuals who paid likely subjected to a delinquent penalty?
Absolutely.
Okay. So
the system automatically rejects any payment received after the 10th because
it's not the 10th.
If it doesn't include the penalty, the late penalty. If you make a payment that is not the entire payment plus the penalty past the 10th,
then
the system automatically turns it back to you.
Okay. And then just finally, there was an email here that I found very entertaining, the top of page 391. With all due respect, it appears you have spent many hours researching and protesting what amounts to a $51.46 penalty. Is that actually correct, from your understanding?
That is the amount of the penalty, yes.
That's at
Now,
issue.
whether or not that they've spent too much time debating it, that's not for
That's-
me to decide, but that was the
But
amount
we
of
have
the penalty.
certainly spent much more than that tonight just waiting and processing this.
I can tell you that we have spent more than $51 of city time researching this matter.
Considerably more, perhaps. Thank you very much.
Probably. But that's, that's not a consideration.
Understood. So maybe I can follow up with the complainant, Ms. Liu.
Sure.
For Mr. Howe. Can you help me and shed some light on that? Is this in fact over just that small amount of money? And secondly, is this report not sufficient to demonstrate that they received the payment on December 11th and not December 10th?
On the issue of the insignificance, my thought was if it was so insignificant, the city took the trouble of returning the payment and having to deal with the bank going through the system and all that. I believe if you read my complaint and the supporting documents, I mentioned that how they can justify all the costs involving in this. If they thought $51 was insignificant, why chase after that then? Mm-hmm. And can they justify the costs involved in returning the payment and trying to collect $51?
I think they're somewhat constrained by the state revenue and tax code as to what they can do and whether or not they can grant a waiver under the applicable circumstances. That's my understanding.
I do think they have the discretion, and that itself is not really the key in this case to me. Is I did not even claim that we were not late. I basically just wanted to see the evidence supporting their claim that we were late.
And as to
we
this
could
report,
be late.
Understood. And as to this report being sufficient evidence of that,
That's an internal report which can be based on input by their own personnel. And when they input the date received, it can be interpreted in many different ways based on the source data. That's what we were after. It could be the day that was the transaction was processed, which could be later than the actual day that the payment arrived in their office or their bank.
and if that's the only report that they have to document when they receive a payment, then that's all there is.
No, I think through my online research, the banks are required to maintain records, what they call ACH entries. Those are the source documents based on which the individual bank will prepare their own report.
But that may be a document that's held by Wells Fargo or some other bank and isn't held by the city. And if it's not a record that the city has, then it may not be a public record subject to disclosure under the ordinance.
That is true. However, they did not communicate that to us. If that were the case, they did not say, okay, Wells Fargo has this document and you need to go to whoever or wherever to obtain this record.
Madam Chair?
Yes.
May I ask a question?
Member Highland, go ahead.
Jamie, just a quick question. What is your relationship to Gary Howe, and is Gary Howe the named trustee of that trust?
Yes, I actually had brought the trust document.
Okay.
He's the successor. As I already presented this in my rebuttal to Ms. Proffitt's letter after we filed a complaint.
Okay. And is Mr. Howe's bank Wells Fargo?
No, actually, that was something I wanted to clarify, which is what Ms. Proffitt said was inaccurate. We did our online bank. Wells Fargo is not our bank. We did our online banking. Our bank is, I don't recall whether it's in the documents that we presented you, but I can certainly clarify that. Our bank was ING Direct. And we did do online banking through ING Direct. In 2012, it was ING Direct, but then they have become a Capital One 360 now.
Okay. So do you, and perhaps forgive me if I haven't seen them in the package, but do you have documents showing that you deposited on your side from ING Direct and the date and the time?
Yes, we requested from ING Direct, and ING Direct used what they call third-party service provider, which would be check-free, and they obtained from check-free what they consider the remittance receipt when it was remitted, and it shows it was the 10th December 2012.
And is that in our package?
Yes.
What page is that?
I don't know in terms of your packet page number.
Okay. Just describe the title of the page to me.
Okay, I believe I have it here. I can just put it on the...
I mean, while she looks, for the rest of the members, I'm thinking if indeed they made this deposit online in the afternoon or the evening on the 10th, it's possible that it was recognized the next business day, which would have been the 11th. So I'd like to talk to Ms. Prophet a little bit more about that and what their policy is on those. But have you found that page?
Can you see that?
Madam Chair?
Member Nee.
Yeah, I would caution all of us that what we're interested in here is a public information matter.
Yeah.
Not the timing of the payment, not the timing of the recording of the payment. There was a request for information, and the claim of the complainant is that request drew absolutely no response. And that's what we're here to examine.
Yeah, I don't think we're here to determine, all the intricacies of did you pay online, did you pay through ACH, what did ACH do? As we all know, our jurisdiction is really narrow here. I wanted a public record. I didn't get it. We didn't give it to them. Here's why. So I thank you, Member Nee, for let's focus back on that again.
Thank you.
Bring it back to the topic. I think this shows that indeed there was a transaction here with SFTC, and on their end they're showing it the next day. So that document did exist. The question is, when did they get that document? And it's after your requested period, if I'm not mistaken.
Yeah, we can only obtain information from the sending half of the transaction. And what we were trying to get was the receiving half of the transaction from the tax collector's office or their bank, but we didn't receive anything. And also, I would like to add that we only added the city attorney's and controller's office because the tax collector's office kept just telling us to file a claim, and they defer their responding to further questions to the city attorney's office. So that was the only way that we could even make inquiries or hoping to get responses to our inquiries.
Member Pilpil?
So, thank you. So to follow up with Ms. Prophet. So in addition to the TDA 820 report, for lack of a better term,
Yes.
do you have any other documents that indicate when payments are received? Do you have access to this supposed Wells Fargo document or report?
It's my understanding that communications between the city and this taxpayer originated with an email from the claimant to the Office of the Treasurer and Tax Collector quite some time ago, I think February 1st, 2013. And basically throughout the last year, initially at that point, the tax collector's office did turn over some documents. And the conversation was evolving. The claimant would sort of clarify in an email, and we would try to produce the document that was responsive to that request. That said, I will admit that at some point, I think shortly after that email that you cited about, how much resources were going into this, my office sort of dropped the ball, and I think that's when the claimant tried to contact the controller's office, and the controller's office, I think, gave a real effort to try to facilitate getting the information that they were really asking for, but the controller's office did not have access to that information, and I think they did recommend that they file a claim.
Understood.
If you file a claim with the city attorney's office, that would be a way to say, we think we need this refund because of this reason.
Which is different from your waiver process. That's their process.
Yes,
not yours. Okay.
I think maybe they did file a waiver request. I'm not sure, but
All I'm asking very clearly is if you have any other report that indicates when payments are made or received.
we do,
particularly
and
some-
we've provided them. This is the one actually that my office assures me shows when the payment was received. This is, in response to their ACH request. But prior to producing this record, we also produced.
Do we have, I'm sorry, I'm having trouble seeing that. Do we have that in our packet?
Yeah, you have that one. We also produced some earlier sheets. I'm sorry, I didn't have the packet. I could take a look and see. But to Member Nee's comment, this is about a Public Record Act request, and we have provided all the records that we have regarding this payment. Some were provided back in 2013. Most recently, it was that redacted spreadsheet that was provided. When this matter came to my attention, we took all of our steps necessary to try to comply with the Public Records Act request.
Okay, so there isn't, well, all I'm trying to determine is there isn't any other document that says what time on the 11th that it was received, but this document should show that it was received on the 11th and not the 10th, and that's all you have.
No, there are other documents. I was just trying to find out where they are in your packet
Okay.
that had been produced earlier. I have them with me. I can just, maybe it's faster if I just hand them to you.
Or you can put it on the overhead.
Okay,
All
I can
good.
do that. I feel like my 7th grade science teacher here.
Oh, yeah, we saw
we call
that,
it
but we-
retro. Yeah, we like to say we're retro with the overheads.
Okay, so we
Have you seen that record?
We have this, but it's hard to read. What this is showing is December 11th, but it doesn't have a time. It's just a batch and sequence number. But in any event, that is showing received on the 11th, not the 10th.
Correct.
Okay.
Now this one's really hard to read. I was trying to look at that at my monitor today.
I don't think we have this. Did someone else see this? I don't think I've seen this one.
Let's see if I can, that's,
And this also was provided to the complainant?
yes, and right here, it has the received date, 12/11.
And that's actually
Should've brought
coming
my
out of
glasses.
Wells Fargo.
Can you expand it just a little bit?
Yeah, and then I have one more.
Yeah, let's look at this
Somewhere.
in some greater detail. Well, anyway.
Yeah.
It is, actually.
Whoa.
I think that's the same information as we saw in the other report.
Yeah, they all essentially have the same information.
Is this by chance a record that Mr. Gadd would want?
Okay, but all of these documents were provided to the complainant.
Correct.
Okay,
Okay.
so he got this.
Got it.
And Ms. Prophet, the way they did pay was that appropriate? I know there's very specific instructions online as to how you can pay, through your service that you provide, but this was from a checking account to SF tax collector. So was this an appropriate way to pay?
Yes, it's a totally acceptable way to pay. You just need to pay and allow enough time to ensure that the transfer will clear if you want to make your payment on time.
So if they paid it on December 10th at 11:59 p.m., would that qualify as a timely payment?
No.
Okay, so
it had to be received by the city
either by mail or by interbank transfer, whatever.
Right. There's a few ways you can pay. If you pay by mail, we're going to look at the date that your mail is postmarked. So if it's postmarked the 10th, you're going to be fine. It's like paying your federal income taxes. Right. Or if you use the city's payment portal, that will be counted as a payment at the moment the transaction is completed. So as long as it's by 11:59 on the 10th, it's going to be timely.
The money was good, the timing was not.
Again, we're
let's
keep it to the public records aspect here. The question is, was the information provided and was it done so in timely fashion? That's what we're looking at.
Mm-hmm. Okay. Well, if you follow the dialogue between our office and the claimant, the dialogue evolved. When they initially started requesting documents, we provided responsive records, and then ultimately it came down to this ACH document. We provided what we have. I think the claimant herself even said that that's a document that banks have. Maybe she needed to go to Wells Fargo or ING Direct or Capital One 360, whatever they were called at the time. At this point, we don't have any other records to provide.
Okay, so
just getting back to the, as Member Nees said, on February 1st, the complainant sent the email. On February 8th, within 10 days, they responded, not with the documents that they requested, but that saying it was received on the 11th. They're not at dispute whether they're late. They were asking for the document showing receipt of said funds. So my thoughts at this point is there was a violation, pure and simple. The fact that there was a late or whether it was a $51 penalty is secondary. I'd be interested to hear what members think about that.
Do you have anything on this, Member Nee, before we move to rebuttals? Okay, anyone else? Member Sims? We're ready? Okay, so what happens now, Ms. Prophet, is you, the respondent, gets 3 minutes for a rebuttal and conclusion, if there's anything more you want to say, and then we'll hear from the complainant. And, okay, he's right there, but I think you have, Mr. Zittrain, Ms. Prophet has 3 minutes. You have the opportunity for 3 minutes if you want. Okay, carry on.
Well, I think I've shared with you all of the facts I know about this transaction, but I can say that the communication initially with my office began with an employee who handles refunds, and when he received this message, he probably should have forwarded it to the department that handles Public Records Act requests, which would have been me. I'm sorry, I'm
going to interrupt you a second. Member David, I think it's highly inappropriate for you to be talking to a respondent in this case. Thank you. Carry on.
And I think the reason why he was just trying to, resolve a question from a taxpayer. But as that conversation sort of evolved, there are many times when it probably still should have been transferred to my department to review. I think had that happened, we would have been able to respond to the claimant, in a much more expedient manner. I think our office is really working hard to be compliant with the Sunshine Ordinance. We take it very seriously. And we were not trying to withhold information from these people. We were just, I think, maybe, I don't know, they got a little bit tired of responding to the emails, I suppose. That's not acceptable. But it wasn't out of any malice or disregard for what our jobs are. And at this point, I think we have responded, and if they have any other questions, we're happy to assist them. Thank you.
Okay, Ms. Where is she? Ms. Liu?
Mr. Zittrain?
He's deferred. Yeah, Mr. Zittrain, we've waived, for the record, you've waived your 3 minutes. Okay. Ms. Liu, our complainant.
In terms of the complaint to the Sunshine Task Force.
Thank you, Mr. Piccarello. For the record, we are adjusting the microphone that seems to have taken on a life of its own.
Thank you. In terms of our...
Can you restart her clock? Oh, okay.
What we were hoping that the task force can resolve for us is not about whether we deserve a refund, we have a valid point for a refund, or but rather whether they claim that they have provided all the documents available. But my understanding of the Sunshine Ordinance is it's not that you just say, okay, here's all we have. But I request very specifically the type of documents, that document that we were looking for. If it's not public record, we expected that they would tell us that. They didn't. If they don't have custody of the document, but it's available somewhere else, in this case now they are claiming that their bank, Wells Fargo, maybe. We had no idea where the document would be, but in terms of Wells Fargo is their service provider acting on behalf of the tax collector's office. The tax collector's office, to be helpful, would be able to obtain that document from Wells Fargo. And Wells Fargo, by the ACH rules, has to maintain that record. So there is such a record, or at least should be, if they follow the rules. But they didn't tell us that either. So basically, we were told nothing about the information we were seeking, whether it was available or where we could get it. They keep pointing to the reports that they provided us, which were internally generated. I could just write up something and input into a computer and make a report, and that, to me, is not a valid source document in terms of trying to show when the actual receipt date was. They can input like when they process the document, which is not the same as the day they received it, if you want to argue from the date point. But again, I think we are sidetracking away from the public record issue, which is basically they did not provide the information and did not tell us why or try to help us obtain it. Or if it's not obtainable, they could have told us that too.
Thank you.
Thanks.
Gentlemen, do I have a motion? Does anyone have a motion they want to make?
Well, I think there is a violation here just because the information they did ask for was provided ultimately. So clearly we have a violation. searching to see what actual codes that are applicable.
I think just to,
Mr. Quilla?
I'd advise the task force just to review the actual correspondence back and forth between the treasurer's office and the complainant in their emails. I think there was a certain point where the complainant wasn't even sure what they were looking for, so there was a lot of back and forth email just to determine, okay, this is what we actually need. Now we're making a request. I think I've laid those out in my memo for this. It could be found on page 367. If you want to just take the time to review the back and forth and then determine whether or not you think there was a records request violation from that. I only mention this because I think we spent a lot of the time during the discussion just figuring out what exactly a third-party processing payment was and all of those issues.
Member Pilgrim?
So perhaps as relevant there, the first email dated February 1st in our packet at page 394 in its original, Dear San Francisco Tax Collector, our bank notified us today that for even more details, we have to make an investigation request to the bank. Please explain why you returned the payment and why it took nearly 2 months since you received the payment. You know, that's open to some interpretation. I would reasonably interpret that as saying, please explain why you returned the payment, just the plain language, which doesn't necessarily suggest a public records request. It's just asking for an explanation from the tax collector as to something that transpired. Then I think over the few weeks in the back and forth with the email, it became more clear that they were looking for specific documents to refine that. So it doesn't appear to me that there was a delay in responding or some intent to not disclose information. I actually think that this is a good faith dispute about the timeliness of a payment. But it doesn't appear to me that the public records were delayed or not provided.
I agree.
Member Sims, Member Nee?
Yeah, I'm inclined to think here that, I guess there were some glitches along the way that shouldn't have happened. The respondents have admitted as much, but I don't see really any deliberate violation of the public records request. And I think, Bob, the respondent, the treasurer, the tax collector's office has given the requester all the information that the tax collector's office has on this. I'm inclined at this point not to see a violation.
Yeah.
Not even of 6725 immediacy response, just because there was a.
Was there a was this an IDR?
No, but it was outside the 10 days of what they eventually got.
Well, then we could find 6725A if there is such a motion.
I'd like to propose a motion to find a violation of 6725A.
Second.
Okay, so we've got a motion and a second.
Public comment?
Public comment discussion. Do I have any? Why don't we go with public comment, and we'll have our last little discussion here. Come on up. Public comment on the motion.
I'm in favor of the motion. The respondent doesn't have to do the act deliberately, as long as the respondent does it not in compliance with the Sunshine Ordinance, so it could be negligently. Respondent did say she dropped the ball, and there wasn't a follow-up question to her, how you dropped the ball. Perhaps that would have explained why the response wasn't timely. So I support the motion, but I'm a little befuddled as to how you found jurisdiction over the city attorney's office and the controller's office. And moreover, the controller's not even here. So if you have jurisdiction over the controller's office, then you should make some finding for not appearing tonight. But I don't think you have jurisdiction over the controller's office or the city attorney's office. The matter is in the city treasurer's jurisdiction regarding this dispute. But I'm in support of the motion.
Ms. Liu? Officially, probably not, but you've been here all night, so come on up.
In terms of the sunshine ordinance sections that might be violated, 6721C mentions that custodian of any public record when not in possession of the record requested, which seems to be what Ms. Prophet of a tax collector's office is claiming, that they provided all the documents and nothing else related to what we were requesting, shall assist in requesting, directing a request to the proper office or staff person. And
which one is this?
They did not do that. And Wells Fargo is basically the representative for them in terms of receiving the payment. So they could very easily directed us to obtain the document from Wells Fargo.
Right, but we don't have jurisdiction over Wells Fargo. We only have jurisdiction over departments in the city.
Yeah, but I thought that the Sunshine also mentions that anyone acting on behalf of the city would be under the Sunshine ordinance also.
It's through the department that they work with or for, so we can't compel Wells Fargo to produce records.
Yeah.
It's not about compelling, but at least you could have provided us. That's why when you mentioned that the email back and forth with the first batch, when we started the inquiry with Mr. Brian Poole of the tax collector's office, we were trying to find out where we could obtain the record, if not through the tax collector's office, who at Wells Fargo or anywhere else at the time. We did not even know the bank was the Wells Fargo. If you read through the email trail with Mr. Brian Poole, he did not really help in terms of we were trying to find out who could provide the document.
Ms. Liu, I'm going to have to stop you because we're about to lose our quorum. Right, we are 5 now.
Bruce?
Bruce, are you going to? Well, we'll see you in a few minutes then. Okay.
Okay, so
we're going to.
Why don't I move that we?
You're not leaving.
Why don't I move that we recess the meeting until Member Oka returns? Because that's all we can do.
Or the chair can just declare a recess.
Yeah.
Yeah, we're going to take 5 minutes. Okay. And when we come back, Ms. Prophet, in the interest of equal time, I'm going to give you a couple of minutes to speak to us if you want to. I want to keep this even. So 5 minutes.
Anything on the rest?
Okay, I'm reconvening special meeting of the Sunshine Ordinance Task Force at 9:05. Mr. Clerk, where were we? We were going to offer Ms. Prophet a few more minutes, right?
Yes.
Ms. Prophet, we're giving you rebuttals and conclusion version 2.0.
Okay. This will be brief. I understand that there is a motion under consideration that the Treasurer Tax Collector's Office violated Section 67.25 subsection A of the Sunshine Ordinance for not immediately responding to the claimant's request for a record. I would just want to point out that between February 1st, 2013 and March 18th, 2013, we had 12 different email communications with the claimant, and during which time we provided the records and the information that we thought that the claimant was requesting. Towards the end of those communications, it became clear they were looking for this ACH statement. I really believe that the tax collector employee thought that he had provided the information, and in his final communication, he said, please take your communications to the city attorney's office, meaning through the claims process. Because while, yes, they were looking for this particular document, I mean, the purpose of it was in order to get a refund of the penalty payment, and that could only be affected by a claim at that point. So,
okay,
I would just like you to take those points into consideration as you consider the motion for a violation of the immediacy provision. Thank you.
However this motion goes, Ms. Prophet, I think you said something a little bit earlier in about how, well, we kind of bounced around, we may have dropped the ball. Just between us and this body, if this comes up again, let's use, if nothing comes out of this, let's use this as a learning experience going forward. So, Mr. Clerk, let's read that
On a motion to find the treasurer tax collector in violation of Sunshine Ordinance Section 67.25A regarding timeliness of response. Member Nee?
Aye.
Nee, aye. Member Pilpil?
No.
Oh, no. Member Sims?
Aye.
Sims, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
No.
Fisher, no. The motion fails.
So again, I'm going to use my role as chair here. Ms. Prophet, and Mr. Zitch is not here. So you prevailed in this case, but how do I put this? I don't want to see you here again with another case like this. Just, think about the public and, how we move forward on this. And like I said, use this as sort of I don't know. Seems like everybody that comes through here learns something they didn't know before. So that's all I've got.
And actually, further to Ms. Prophet, prior to you assuming this position, I dealt with Mr. Augustine and Mr. Cato to some extent on these issues. So if there are any issues about forms or procedures within the office, we can certainly bring that up at EOT. And it sounds like you're working on better integration across the different divisions within your office. So thank you.
Yeah, we're here for you. Or more appropriately, Mr. Young is here for you.
And to Ms. Liu, Mr. Howe,
Yeah.
thank you for waiting all night to hear this, and hopefully don't be discouraged. Bring other cases to us as you see fit. Hopefully you learned something here today as well. I personally thought that you had a valid case here, and I want to thank you for appearing before us.
Yeah, thank you.
Thank you all.
Mr.
There being no further motions, the matter is concluded.
Thank you.
Item number 8, Sunshine Ordinance Task Force Annual Report. I believe I have left you copies of the annual report at your...
Yeah, I don't think I want to take the time to go through this line by line, but what I do want, what I think is missing is I need the subcommittee reports from members Washburn and Pilpel, right? I can't do anything with this until... But I can't
That
forward
is
this
correct.
on.
And I will provide the tables of the complaint tables.
Okay. So this is, it didn't take out
For
the
your
pink,
information.
the pinkness. She forgot to take out the pink on this.
That's probably my...
Okay.
I just printed it as I received.
All right. So, gentlemen, if you could look through this, this is a draft. Did we send this as a soft copy to everybody too?
I can do that.
Yeah, let's do that. Wait till tomorrow. I want to de-pinkify it and catch any other, there might be, because Kit and I just kept going back and forth and back and forth. I want to make sure that it's the final.
Yes, I will wait for a new copy
I'll
from you
send
before I
something
forward
in.
it.
So if everybody could look at this with sort of a view that this is our first shot at it.
So,
Yes,
Madam
Member
Acting Chair.
Pilpel, yes.
So to be clear, the period that we're going to cover is May 2012 to April 2014, so we're going to ignore January through April of
We
2012?
weren't here.
Well, Member Nee was.
We're going to ignore it.
Okay.
I shouldn't say we're going to ignore it. It's not going to be covered under this. That's a better way of
Okay.
putting it. It's not going to be covered by this annual
Then
report.
can I just suggest that you have some line in here that explains?
We do. We do.
Where?
Don't we?
No.
I thought I said that somewhere in here.
Just says what the period is that's covered, but it doesn't explain really the gap.
Okay, well, I will ask everybody to make your comments to me and Victor in the next few days.
Okay, and
I would remind you to
Yeah,
put
okay.
together your,
and I may ask for Member David for some help on the EOT portion. So if this is going to be more narrative than numerical, I'm happy to follow that format. So it's more.
well, I mean, there's numbers where numbers are
Right.
needed. We had 59 cases, there's still 9 out. This is how many we covered. I mean, Victor's been very good about getting
Okay.
those numbers.
Okay, and then we will have as attachments the
Copy of the complaint logs.
the complaint logs for 12, 13, and 14.
Yes.
Yeah, we'll have that. So, and let me, Member Neve, you happen to talk to Member Washburn. I mean, don't go Hemingway on these. Just,
Yeah, I know.
Just
A
the
page or
facts.
two.
A page is fine. What you did, how many cases you had. You've done this before. I mean, I'm pointing at you. It's not yours to write, but when you discuss this, when we all three discuss this tomorrow at CAC, we want to just get a brief, concise attachment. Because they weren't long in the past, right? Victor, I mean, I looked through them, they were short.
Buried.
Okay.
So is our goal to have this back as an action item for the June 4th meeting?
Yes, I would like to. Is the Rules Committee okay with that? I mean, because we presented.
You did not
Twice.
present an annual report to them. You just presented information to the Rules Committee.
Yeah, we presented a abridged version,
Yes.
but they haven't demanded something by tomorrow?
They have not.
Okay, so let's go for, so let me put this, let's have this tied up by our June 4th meeting unless we hear otherwise.
Do we need to act to continue this or not?
I would appreciate it if we can continue it to our next meeting.
Yeah, let's continue it to the next meeting.
Is there any objection on?
Do you have any objection to that? No? Seeing none, go ahead.
And there's no one here from the public. All right.
And for the record, there is no one here for public comment.
Item 9, approval of the Sunshine Ordinance Task Force, April 30th, 2014 meeting minutes. Please note that I have taken Member Nee's suggested edits and have integrated them as best as I could in my version.
I also provided edits, and I'll move to approve with all of those edits.
Second. Madam Chair.
So are we approving that now, then?
Yes, Madam Chair, just a brief comment. I want to note that Mr. Young has taken to time-stamping each item in the minutes, and I think that's a wonderful addition. Mr. Young is to be complimented and thanked for that particular added dimension to our minutes, that they will be very helpful to members of the public who, when they want more detail on what we've done and they want to go listen to the audio recording, this can speed up their finding what they're looking for.
Yeah, I appreciate that.
Yes, and it is my best estimate. It is not exact.
It's better than what
Thank
we
you
had
very
before,
much.
which was nothing. Thanks for bringing that up, Member Nee. Okay, so that's item.
Vote on the minutes.
Can we just pass that without objection?
Yes.
Is there any objection? Okay, so we'll say pass without objection. We're okay over there on the end? Yep. Okay, item number 10?
Item 10, report Education Outreach and Training Committee meetings of April 14, 2014 and May 12, 2014.
Okay, so I am.
I have an announcement on item 12. Okay, go ahead.
Okay, so I'm reporting on those two meetings. At the April meeting, we heard about the James Chafee versus Board of Supervisors Budget and Finance Committee, and had discussion and asked, why am I blanking? Ms. Stefani, right, Ms. Stefani from Supervisor Farrell's office, and I'm still awaiting a document from her a month later. That hopefully was going to change their public comment process for the budget this cycle. We did not hear at the April meeting about time limits for public comment. because Member Oka was not there, but we did at the next meeting, and we talked about the draft annual report. Last Monday at the May 12th meeting, we heard from Ms. Jessen from the City Attorney's Office about their process for handling petitions to the Supervisor of Records and asked for a written set of procedures. She's in the process of developing that, and hopefully will provide that to us sooner rather than later. We also discussed at great length the Arts Commission and their policies and procedures on both meetings and records. And I think we asked for a couple of follow-up items there that I'm still waiting on. And we did discuss with Member Oka time limit for public comment at public meetings, the question of whether 3 minutes means exactly 3 minutes or up to 3 minutes. And that's my summary.
Thank you very much. Do we have the next item?
Item number 11, report compliance and amendments meeting of April 15, 2014.
Member Washburn is not here, so do we just continue that? Member Nee, do you want to, I mean, it's your show if you want to jump in.
I have no comment beyond what's already in our
right.
packet.
I believe that Ms. Jensen from the City Attorney's Office was instructed to write a letter to the public library to ask if there was any additional documents. They have responded to that, and it will be heard tomorrow.
Okay. Next item?
Item number 12, announcements, comments, questions, and future agenda items.
I have an announcement. So we have now 2 people on the Compliance and Amendments Committee, correct?
Yes.
And that does not constitute a quorum.
They would both need to show up.
They would both need to show up.
Yes.
Well, let's just go with that. No. So what I was going to suggest was members Highland and Oka, you're on EOT, right? And with Member Pilpel.
And rules.
What?
I'm on rules as well.
We don't really need
Yeah, you're on rules. Yeah, so am I.
It is on rules.
I'm on rules too. So the offer here is if anybody wants to shift over from EOTC to CAC, I think it would be prudent so we don't just have a 2-member committee, and if nobody wants to do that, I'll shift over. But I want to give anybody else for your kosher where you're happy where you are. You want to stay where you are, or do you want to shift over?
I think I'll wait till the Rules Committee selects some more members.
Yeah, I
Because
kinda
I'm
figured you
interested
were
in the Technology Committee. I don't
Okay.
want to overextend myself.
Yeah, I figured you were going to, well, we would just,
Assuming I'm still here.
there's a meeting tomorrow, right, Member Nee? CAC?
There is one scheduled, yes.
So why don't I, for now, petition the chair, which is me, so okay, I say yes, to go over to CAC temporarily until further notice, until the Rules Committee, the big Rules Committee, those Rules Committee people over there, until the Board of Supervisors figure out what we're going to do and we have new people, I will shift over to Compliance and Amendments. Member Pilpel?
I just wanted
You'll miss me terribly, I know.
No, well, I was just going to suggest so
Yes.
that we both maintain odd-numbered membership, that for the moment that you serve on both committees.
Yeah, I'm going to check with the chair on that one, and she does not approve of that. She will be serving on just one committee. I think you'll do fine.
Well, then we're down to 4.
You're at 4, which is
Okay,
fine. And
all
then
right.
somebody doesn't show up, and now you're at 3, and you're perfect.
I think we have enough odd members on the
I
OTC.
think you,
All
yeah, I
right,
don't
fine.
think you're,
Okay.
I really don't think you're going to have any
So
problem.
you're moving to there from, okay.
If you have a 2 to 2, then flip a coin.
While we were speaking to that, I would like to take a roll call for the June 4th meeting to see if all members will be able to show up.
4th.
Member Washburn has indicated that she will be able to attend, and Member Highland has also indicated that he will be able to attend.
I'm,
And I will not be able to attend.
So
will
I
be
need
able
4
to
more.
attend.
It'll be my.
I have to attend.
Member David will attend.
I have no choice.
Vice Chair Fisher will attend.
Yes, because if I don't, then there's no meeting.
Can anyone else confirm that they will attend the meeting? I need 2 more. Member Nee will attend.
I'm good.
We have our minimum, and Member Oka, I assume you...
I will be here.
Yes, we will have slightly more than
It's like my
quorum.
backup plan. I need to
thank you.
I need to encase myself in a bubble so nothing happens to me.
So let's be clear, for June 4th, we have everyone but Member Sims.
Yes, that is correct. And
Oh, it's almost
I-
not worth
mean, the 24th I'm just going to say the 24th would be difficult, so hopefully June 4th, yeah. Hopefully they have.
Oh, we have a quorum for June 4th.
But nothing's going to happen in terms of.
For the 24th.
Oh, for the 24th. Yeah.
They still have
stay
to
tuned.
get sworn in and all that. It's going to take a while.
Additional roll calls I'll probably do by email.
Did we, so we already set up a special meeting for the 24th?
Yes, the date has been set.
I don't have it. It's going to be in this room?
Yes.
At 4 o'clock?
Yes.
Oh, I didn't have it on my calendar. Okay.
And just a note for the agenda, I think one of the members of the public made a good point. In these special meetings, we're kind of doing collections of cases. We should announce that we're going to hear them as twos or threes or together, just to not go through that rigmarole at the beginning. That might be. It might invite more discussion. But
I can put that. I can note it on the agenda that the chair intends to consider items together. We do that on various other agendas.
Yeah.
Do we have a working plan for June 4th at this point?
Yes, we are. We are set for June 4th.
Oh, yeah, that's a good one. You don't want to miss that one. That's a good one.
And what is it?
Pretty funny.
I'd like to, do I need a motion?
I make a motion to adjourn.
Without objection.
Okay, I've got a motion to adjourn and a second, and I think we passed with no objection, so I'm going to adjourn this 947th meeting of the Sunshine Ordinance Task. 7th meeting of the Sunshine Ordinance Task.